we welcome everybody that's here. We'll move to a call to order and welcome, and we'll move to announcements from staff first.
None at this time.
Wonderful.
Anyone else has any?
We'll then move to, anything? No. We'll move to a roll call of board members, starting with Joel, then moving over to staff.
Paul Wilazinski.
Greg Allen.
Andy Ball,
Catherine Morsani.
Gabe Quisenberry.
Shannon Capizelli.
Dana Alley.
Jason Payne.
Kurt Euler.
Griffin Kearns.
thank you so much. The board was emailed the set of August regular meeting minutes earlier this week. If you have time to look through those and make any comments, changes, or motion regarding the minutes.
I'll make a motion to approve the minutes from August meeting.
Second.
There's a motion and a second. Hearing that, all those in favor, please raise your hand. That passes. Thank you. Moving to disclosure of ex parte communications and conflicts of interest. Any member of any board exercising quasi-judicial functions pursuant to this chapter shall not participate in or vote on any quasi-judicial matter in a manner that would violate affected person's constitutional rights to an impartial decision maker. Impermissible violations of due process include, but are not limited to, a member having a fixed opinion prior to hearing the matter that is not susceptible to change, undisclosed ex parte communications, a close familial, business, or other associational relationship with an affected person, or a financial interest in the outcome of the matter. We'll start with Joel on that disclosure.
No.
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 Thank you so much. Moving to item F, public hearings. Before we start, we want to outline a couple of items for the public here. This hearing is a quasi-judicial evidentiary hearing. That means it's similar to a court hearing. State law specifies particular procedures and rules concerning how this board must make its decisions. The board's discretion is limited. We must base our decision on competent, relevant, and substantial evidence in the record. Our decisions must be constrained by the standards in the zoning ordinance and based on the facts presented. If you'll be speaking as a witness today, please focus on the facts and standards and not personal opinion or preference. General witness testimony is limited to facts and not opinions. For certain topics, however, this board needs to hear opinion testimony from expert witnesses. These topics include projections about impacts on property values and projections about impacts of increased traffic. Individuals providing expert opinion testimony must be qualified as experts and provide the factual evidence upon which they base their expert opinion. We'll also issue a reminder to the audience and to board members that we'll silence our phones if we haven't already to help out with interruptions. And at this point, we'll move to 3 cases that have potentially requested a continuance today. So we'll move to the first of those cases that I've been made aware of, and that's River Knoll.
River Knoll Phase 3 subdivision variance.
Okay, if we'll have the applicant come forward on that one. Yeah, sure.
As well. Thanks.
That's better?
That's better,
Yes,
thank you.
Great. Good afternoon. I'm Will Bowie with WGLA Engineering. I'm here representing Robert Solaski. We're related to the River Knoll variance request. We are requesting a continuance from this board today. We were made aware about 24 hours ago of a neighbor that had a concern related to the variance. My client had reached out to that neighbor, and it turns out they're actually out of the country. So we'd like to have an opportunity to meet with that neighbor and discuss the variance and discuss their concerns, and then come back to you all at a future meeting date.
Sure. Do you have an idea whether that would be possible by the second Wednesday of next month or a further month?
Certainly would think so, Mr. Chair, yes.
And Mr. Freeman?
Mr. Chair, I represent the neighbor who's out of town. Her son is here today, and he's going, that's the sole issue under the agreement.
Okay.
My client, Mr. Chair, would prefer to have a discussion outside of the board. This is between neighbors, and I think we could have a discussion and come back to you at a future meeting date.
If the board discussed and wanted to proceed with the application today, would you be ready to issue your presentation?
I'd like to discuss that with my client first, if
Okay,
that's
sure.
possible.
Take a minute while we talk with staff, and we'll do that. The board can, at its discretion, continue the case or proceed, right? Okay,
That is solely within the board's discretion.
okay, perfect. Sure, yeah. How's next month looking? Do we know yet? On case load?
It's somewhat uncertain as of yet. We have at least one item that was continued from the August meeting, and depending on other matters which are being sought to be continued from today, that will dictate what the October agenda looks like.
Sure, okay. Yes, sir?
Our client would prefer to continue. I think the questions related to the specifics are an encroachment onto my client's property from their property or their driveway. And also there's some concerns related to specific turnarounds related to the variance request. And so I think this gets to the heart of the variance that we're bringing before you, and a discussion outside of this meeting would be preferable to my client.
Okay, any further comments there, Mr. Reamer?
I believe that the issue is the use of Gentle Breeze Lane. I think that any issues around an encroachment or an alleged encroachment are separate from any issues that we would discuss here today. As I understand it, before the board today is a variance request. And it's a variance request that has to do with the subdivision ordinance. We are prepared to talk about that today. I don't think we need to have a discussion about encroachments or anything offline. Again, the applicant for stands ready to proceed today.
And just to be clear, your expert witnesses are in attendance or available today, is that right? If needed?
Yes, the only experts are myself and the client.
Perfect, yeah, okay. Before we open up for board discussion, just one matter of housekeeping. Welcome, Greg, how you doing? We did an ex parte communication disclosure before with all the members. Just wanted to get your readback on whether you've had any outside the board contact or outside public contact with any cases today.
None whatsoever.
Thank you so much, yeah. Open for board discussion of a continuance on this or or proceeding with it on the agenda. Any thoughts?
I'd rather have them work it outside of our time, because we have a pretty full docket, so that would be my preference.
Okay.
I tend to agree. It's a little unclear as to whether this is going to prolong it or not, but I'd rather have the conversation occur outside of council presence for the sake of our time.
All right, well, we'll take a motion on that then. Before we do, actually, let's clear both parties' availability for next month. Second Wednesday is the October 9th? October 9th.
Yes, it would be October 9th.
And we
We
would
think
be
that works.
available. Yes, sir.
Okay.
Mr. Chair, we should be available as well.
Okay, thanks so much.
I make a
Welcome.
motion to continue it to next month.
There we go. We have a motion. Is there a second? Hearing a motion and a second, all those in favor, please say aye.
Aye.
Aye. Any opposed, nay? Thank you. That passes. Thank you. We'll see you next month. Mhm. And the Clark variance, I believe, next. Yeah. Y'all will approach.
Mr. Chair, the
Do we
Clark
get to
variance.
keep
is
you for
us.
this one too?
So
Okay.
this is a bit of a role reversal. I want to clarify, we did not object to the continuance in the last case. We were ready. But we are asking for continuance in this case, namely because my colleague, Bo Carpenter, has a hearing in Madison County and is unavailable today.
Sounds good. Questions about that, or comments, or motion? Next month is good for that.
Make a motion to continue to next month.
Second.
There's a motion and a second. All those in favor, please say aye.
Aye.
Aye. Any opposed? Thank you. That passes. Thank you so much.
Thank you, Mr. Chair.
We'll see you next month. And the Kuhn variance is third on our list of possible continuances.
Is there anyone in the audience here for the Kuhn variance?
They had retained counsel, yeah, or not? I forget.
I believe the applicant had been in correspondence with Savannah Glantz, who is not in attendance today. She would be the one who's able to confirm that.
Okay. Can staff remind us about, on this one, what the applicant's?
This has been continued a couple times. I believe
Right.
this is the one, is this out like in Flat? Kind of by the landfill
Mhm.
of Flat Creek Road or somewhere in that area, and that this is a kind of like a skinny lot where there's a garage that was built.
The
and that
barn.
there- A barn.
We heard part of this case, yeah.
Yeah, you've actually heard some of this. And
And
Mr.
they were gonna, forgive me, they were gonna retain counsel or something and come back,
Right.
and we haven't heard?
I know, it's my understanding that the applicant did contact staff and asked for a continuance, although our policy normally is that,
Is that they
you
appeared?
know, short of extenuating circumstances, you need to be present at the hearing or the hearing date to make those requests.
Given all that, do we feel like doing this one more time and then calling it a day next month? Because it's been 2 or 3 times at least. I don't want to carry it on.
I honestly would, I'm okay to make a judgment today
Yeah,
and just,
and have him resubmit if he needs to.
yeah,
Yeah.
just say deny, and then when he gets his act together and is able to show with all the pieces in, then, then take our time.
No consequences for bringing it back up? He can bring it back?
Just to let you
Yeah.
all know, though, that if you do deny a variance or something like that, the applicant can't come back for another year.
For variance.
Well,
No,
I'm just
I mean,
putting it
it's-
out there.
It's consequences for not showing, not communicating effectively, and drawing it out. It's
not just this
part of
month,
getting
it's-
your ducks in a row.
There's been 2 or 3 months this has happened.
No, it's
That-
like 3
I-
months now. This is 3rd month, maybe 4th month.
I just want to just make sure that you all are aware of what happens,
Yeah,
you know,
okay.
if we moved forward.
Just for clarity, when we say deny, are we talking about denying the request for the continuance or denying the request
Denying
for the
the-
variance?
The variance. Mhm.
I'm of the mind denying the variance, let him have a year to get his act together and review, and then come with a plan.
Just because they haven't followed procedure or communication standards to appear before the board, and that's just, you know.
And there's no possibility of misunderstanding between staff and the applicant?
No, I don't believe so. I mean, he was in the meeting last month when you continued it to a date certain.
The testimony at the time was he'd like to have time to secure counsel and come back.
Well, and he secured
Right.
counsel, he just couldn't get the counsel here that day. It was gonna be for this one.
That's right, yeah.
And so honestly, I think it's not, I think he needs to get his act
Yeah,
together.
possibly, yeah.
So why don't, if I may make a suggestion, if you were so inclined, you could deny the motion to continue at this time. We will then go through the agenda when we get to the case, and we'll try to send him an email or something like that saying that we're holding your case open, but it will be heard today.
And by the end of the meeting, if
And
there's
then,
no
then if
correspondence,
he,
we can
then
act.
if he's here at the time,
Sure.
and then you can handle his case in just the normal course of business.
That's reasonable, I think,
I think
to
that's-
for today, you know, to give him till today.
agree.
And
Does
Sure.
that
Yeah,
work
that's
for?
fine.
Okay.
Okay, so we'll push that, no action needed there. And then that's the 3rd case. Any other, the staff know of anybody else requesting a continuance here?
Not at the present.
Okay, thank you. Okay, at this time, we'll scroll back up to the top of our agenda and move to ZPH 2024-00018, Rivers Edge Apartment Special Use Permit. We've got, who do we have? Shannon to present this one.
Are we still pulling up the plans on here? Just give me one moment. Okay, well, while that's thinking about it. Again, my name is Shannon Capizzali.
Let me swear you in first. Please raise your right hand and state your name.
Shannon Capizzali.
Do you swear or affirm to tell the truth and nothing but the truth?
I do.
Thank you.
I certify that this public hearing was properly noticed and all applicable parties were notified of the meeting in accordance with general statutes and county policy and code. And I ask that all applicant and staff materials be accepted into the record as evidence.
Hearing no objections, those are so admitted.
Thank you. So this is the review of ZPH 2024-00018, the River's Edge Apartments. The applicant is David Roberts with Eminent Capital LLC. The property is located at 101 Sumner Drive in Arden and is approximately 25.08 acres. The development will be served by public water and sewer, and I have a copy of the site plan up on the screen there. That's showing the northern and southern portions of the lot. So the property is zoned EMP. There's no overlays present. The special use permit is for a planned unit development with 180 units in 9 apartment buildings, 2 garage structures, and site amenities. The access is from a private road off of Glenbridge Road through an adjacent property which currently houses a church. The surrounding zoning includes EMP to the south and to the west, with R2 zoning to the north and the east. Existing uses in the area are primarily single-family residential, and portions of the property are in line with the Asheville Regional Airport's northern approach runway. The applicant's been working with the FAA and the Airport Authority to assure compliance with their standards. They are not proposing any deviations from the zoning ordinance requirements as part of this application. And if approved by the board, staff recommends the following conditions, which I'll summarize. Number 1 is that the project must be constructed as depicted on the site plan. 2, the applicant must submit a cross-access agreement or opinion of title for access to the property through the adjacent parcel. Number 3 is that prior to commencement of land disturbance and construction, the applicant shall submit a site plan review permit for the entire project. And 4 is that the applicant must agree in writing to these conditions prior to commencement of site work. And I'm available to answer any questions. The applicant is here as well as a representative of the airport.
We'll open to questions from the board for staff. Please.
Yeah, with the airport, is approval contingent on an agreement from the airport? There's no problem.
So that would be something that could be added to the recommended conditions of approval. And if you would like the airport representative to talk about what those conditions could look like in terms of the wording and what the standard would be, he's available to do that. Those conditions are related to how close this property is to that northern approach.
Can I speak to that just for a second?
Please.
I just wanted to point out the existence of this navigation easement, which is between the airport and somebody, I don't know who it's with because it's been redacted, but this does exist. It's a 3-page series of easements, which I'm going to have some questions about. I'm not sure if this answers your question, if you want to take a look at it.
Mr. Chairman,
Right, yeah. Go ahead, please. Mr. Justice. Yeah,
I'm sorry. Good to see everybody again.
welcome.
We're getting a little bit out of order
Yeah,
in the
Let's,
sense of presentation.
yeah. Let's do
Whether
this.
the airport is even a party, there's a lot of moving parts here, and this is a little bit sort of out of.
If you hold off just a minute, sir, that'd be great. Any other questions for staff in the meantime? The applicant can internalize that question and come back with an answer on that. Anything else for staff? Okay. Before we ask Mr. Justice to continue with the presentation, are there any standing applications? I know I see one from Huggins. Are they still planning to start standing?
There was one application submitted from David Huggins, who is the owner of the subject property.
Okay. Wonderful. Do you want to have him as a party, or do you want to have him as a witness on your behalf?
I think it was a question of not having gone through this process before, and as
yeah.
someone interested, they just wanted to be sure that they're here to support. I haven't even met the gentleman. If he's here, I think what I've heard was he just wanted to attend, and sort of rah-rah, but not as a witness, not as someone in opposition. I don't plan to
Okay.
call.
Let's verify that real quick. Mr. Huggins, if you'll come forward. Thank you. We'll swear you in first, then,
Over here?
yeah, sure, thank you. You'll speak into the microphone if you can.
All right, please raise your right hand and state your name.
David Huggins?
Do you swear or affirm to tell the truth and nothing but the truth?
Yes, sir.
Thank you.
Welcome, sir. Did you have plans today? Did you have plans today to speak as a witness, a lay witness at the end of the proceeding, or did you plan to participate today as a party withstanding and cross-examine and bring your witnesses, et cetera? Which one do you have in mind today?
Well, no, sir, I was really here to view the process and see how the project is going,
Perfect.
and really no more than that at the present time.
What the board will do after they've had a chance to present their case, we'll open up for public comment. We'll have you come up and do the same thing here and kind of state your
That'd be great.
opinions and things. And then we'll have an opportunity for the applicant to respond if they want to. So thank you for being here today.
All right, thank you.
Thank you.
On your standing application?
Sir, again, I'm not sure about the legal terms. Again, I just wanted to be here to view
I
the process.
I understand. I just want to make sure for our record, if you are just going to be a witness and speak at the end, you don't have to. That's nothing like that. That's very different than someone who's standing, who basically would be acting almost in opposition to the applicant.
Right, no, sir, I don't want to.
Okay. So,
Thank you, sir.
Thank you.
We appreciate you.
Thank you.
Mr. Justice,
Thank you.
welcome again.
Welcome. Mr. Chairman, we've done this rodeo. I will hopefully not do much talking. We have 3 witnesses for you, and we'll start out with the civil engineer. Jared, if you'll come on up, and he'll give his presentation.
Good afternoon, Board. Jared.
Please raise your right hand and state your name.
Jared DeRitter.
Do you swear or affirm to tell the truth and nothing but the truth?
I do.
Thank you.
Welcome.
So Jared, if you would just introduce yourself, and then we'll have you recognize your written statement. I'll hand that up, and then I'll let you go.
Sure, absolutely. Jared DeRitter with WGLA Engineering in Hendersonville. I have over 15 years of experience in land development activities, and here to represent this project.
And are you licensed in the state of North Carolina?
Yes, sir, I am. Licensed professional engineer in the state of North Carolina.
Okay, and have you prepared a written statement for purposes of the record today?
Yes, I have.
And is this a copy of your written statement?
Yes, sir, it is.
Mr. Chairman, I'd like to hand up Jared's written statement as Exhibit A to the record.
Please do.
Can I ask if this is the same as the affidavit that's part of the record already?
I did not see that in this packet. I've reviewed it generally and have not seen this yet, so.
So there was
Exhibit A,
material
yeah.
submitted to staff yesterday.
Yeah,
I think
yesterday.
it was uploaded, but in terms of not sure whether that was part of the record yet, just we're boots and suspenders here a little bit. But yes, if you looked at what staff may have provided as of yesterday, it should
It's
be
the same thing as this?
Yes,
It's
yes, sir.
it was in an email yesterday, yeah.
Oh, okay.
From staff, yeah. Mhm.
Okay.
So Jared, as part of your written statement, you've included a CV that outlines your experience as a professional engineer, is that right?
That's correct.
Okay. Mr. Chairman, I'd like to tender this witness as an expert in civil engineering.
Seeing no comments or objection, those are accepted.
All right, Jared, if
So
you'll
accepted.
go ahead and describe the project.
So you all have the site plan before you, I believe. A couple of different things I wanted to denote. Ownership, there is a parent tract. So just for clarification, there is a parent tract that's approximately 25 acres. And that parent tract is currently owned by Mr. David Huggins, who was up before you just before I. So that parent contract is under contract, and then there's also an additional 1.3 acres for access through an adjacent Asheville Pentecostal Holiness Church parcel. It is the intent that after approval of a Board of Adjustment suggestion, that we would actually enter into a recombination plat and recombine that all into one parcel with one ownership for the applicant, which would get you to a total acreage of around 26.38 acres. So I did want to clarify that. If you'll notice on the site plan in front of you, the project is pretty much bordered entirely by EMP zoning. That's to the north, to the west, and to the south, and only to the east is it bordered by residential. You will notice to the east where there is residential zoning district bordering us, we have actually moved the site plan improvements further away from that residential, where it's only required to be 20 feet. We have actually went up to 200 feet away from that residential zoning district. And in fact, many of the setbacks for the buildings have been, I would say, doubled or greatly exceed what's required per the zoning ordinance for the position of our buildings. But in general, as Shannon mentioned, there are 9 residential buildings on this project, and each building has 20 units. So 9 times 20 gets you to our 180 units. The max building height allowed in the EMP district is 90 feet, and we are proposing a building of 44 feet. We do have a clubhouse, we do have 2 garages, we do have a playground and a dog park. One thing that I really want to bring to notice is that we have a built-upon area, which is our buildings and our surface parking, and that built-upon area is only around 5 acres or 21% of the total parcel. So we're leaving a lot of green space there. You can see on the site plan, typically green is good for development these days. Inclusive in that built-upon area is sidewalks throughout the community. We want this to be a walkable community. And then you'll also notice on the site plan to treat the built-upon area, we do have 3 separate BMPs, or some people call them stormwater control measures, that will control and treat stormwater for Buncombe County. Again, the open space, we're at 61%, and the majority of this open space is currently wooded and would be preserved. And then our density is well below the thresholds allowable of 12 units per acre, and we're sitting here at 7.18. So I think a conscious effort to conserve wooded property has been definitely attained here on this site plan.
Can you repeat what you just said?
Yes, sir. So the allowable density for the EMP district is 12 units per acre, and we're at 7.18 units per acre. And the open space, which is predominantly the green areas on the Hatch site plan, is approximately 61% of the total site area.
Can I ask a question? No? Okay. No, you may not. Something comes up.
Just one quick thing that I wanted to bring to your attention. I know it was stated in the staff report about our project being in direct alignment of the airport runway. We have had several communications with the airport, and in fact, there is an exhibit in the documents that Mr. Justice gave to you that shows that the project is in fact not directly in line with the future runway. There's an offset, and in that exhibit, that offset is shown. In addition, the project is over 1 mile away from the current terminus of the current airport runway. So we're talking about 5,385 feet-ish away from the current proposed runway. And I think that covers it, Mr. Justice.
In the analysis, you did review a future plan of the airport in terms of expansion of the airport, right? took that into account?
That's correct. So the TRC comments did suggest that we reach out to the airport, and which we did. They supplied several documents, which you all have seen. We prepared some exhibits and shared those with the airport. And then we got confirmation back from the airport that basically there's a horizontal component and there's a vertical component, but both of our components were basically in compliance with the FAA regulations. I'm sure Mr. Jared Merrill could reference that a little bit more if needed. But also in the report that's before you in the affidavit, there's a detailed explanation of each of those items and a little bit more specifics. But in a nutshell, that is true, Mr. Justice.
And in terms of your understanding of the airport, they have indicated they agree with your analysis, correct?
Correct. So we do have email correspondence that suggests that the exhibits that we prepared were true and accurate, and they agreed with that analysis.
Now, you touched on the provision of certain amenities. There's a clubhouse, you indicated a dog park and a playground. In terms of the playground, can you describe that in a little bit more detail?
Sure. So, board, if you would, there's an exhibit. Sometimes a picture is worth 1,000 words. So there is an Exhibit 8 in your packet. The client, Eminent Capital LLC, does have an inventory of apartment projects, so they are not new to the apartment game. And some of their projects, there's representative pictures of what the playground might look like. 3-page exhibit there, but this gives you an idea that there would be a playground, with conventional slides and different activities for kids. The second page of the exhibit is intended to show that there may also be a part of the playground that has a picnic table and or cookout space where residents could use that amenity area. And then the third page, which has been quite common these days, is also, in addition to the playground, an outdoor fitness equipment or a kind of a workout area that could be added on and has been added on to several different apartment complexes they've done.
So Jared, just to clarify, I think you referred to Exhibit 8. This is actually going to be a supplement to your affidavit, right?
Okay.
And is that Exhibit 8 that you were just referring to?
It is, yes.
Mr. Chairman, I'd like to hand up as part of his affidavit a supplement, which is this Exhibit 8.
Okay, please come forward with it.
Is it possible for the neighborhood that joins us to have a copy of what we're talking about?
I'll ask staff how possible it is to make it available or to,
We can, depending on the number of copies, I'm happy to make a copy. We'll go make a copy.
if that's okay, let's do
Okay.
make a copy available on one of the tables over here, and we can have people, take a look
Okay.
at it if they want to.
Will do. Well,
So
that-
maybe not need to, actually.
so how
yeah.
about, may I approach and grab
Let's do
grab
that.
your thing? Thank you.
And for the public's reference, there is also all the application materials, all the exhibits, aside from what's being admitted as an exhibit or a item today, are online right now, so.
Mr. Chairman, I have an extra copy of the affidavit.
Thank you so much.
So Jared, your affidavit includes your report that goes into detail about describing the project. It has, of course, your CV. But on the first page of the affidavit, you opine about compliance with the standards of the Buncombe County Ordinance. Do you see that?
Yes, I do.
And so, based on your expertise as a civil engineer, do you believe that this project complies with the standards of the Buncombe County Ordinance, which are replicated in your affidavit on pages 1 and 2?
Yes, I do.
Mr. Chairman, those are the questions I have.
Thank you so much. Questions for Mr. Derider from the board?
No questions for me.
Okay. We're all set. Thank you so much, sir.
Thank you.
Mr. Chairman, I'd like to call John Palmer.
Sure.
Please raise your right hand and state your name.
John C. Palmer.
Do you swear or affirm to tell the truth and nothing but the truth?
I do.
Thank you.
John, if you'll go ahead and introduce yourself to the board.
My name is John Palmer. I'm a commercial appraiser in North Carolina. I hold a designation as MAI, AIGRS, and a CCIM. I've been an appraiser for almost 20 years, in real estate for probably 40. I've done lots of different types of projects, impact studies and things like that. I've been before this board a number of times.
Have you been tendered as an expert and accepted as an expert in front of this board
Yes,
in real estate appraisal?
yes.
Did you prepare a written statement for the board, and is this a copy of that?
Yes, it is.
Mr. Chairman, I'd like to hand up this exhibit as Exhibit B. for the
Please.
record. It is the same, yes. Chairman, I apologize for the amount of paper duplication. I apologize. We don't get paid on the piece of paper.
Does any board member wish to hand me their copy of the exhibit so I can hand it to the?
Applicant has an extra.
May I approach? Oh, thanks, Craig.
And if you don't mind, I didn't mark that as Exhibit B. Did I hand you one
Yes.
marked as Exhibit B?
Yeah.
I'm going to switch with you. Okay, good. Thank you. All right. So, John, if you'll just,
Hey, Craig, before you get going, what do you want to call this?
that was Exhibit 8, because it's a supplement to the affidavit.
Exhibit 8 to the affidavit?
Yes.
Exhibit A.
Correct? Yeah. There'll be a quiz afterwards.
That'd be a quiz.
John, if you'll explain to the board what you did related to the project, of course, get into a little bit of the weeds of the written statement.
Sure. I was given the information for the proposed plan, the location, lots of other different types of information I typically ask for. I then identified other projects that I thought were similar to this one, number of units, number of the height, things like that. I then went out and looked in the market. I've got a database that is pretty extensive, and identified projects that I thought were similar to this one. And I went through and looked for differences in values. Typically, what I look for is sales, resales of the same house or land, or even sometimes triple sales. And then I've calculated a appreciation rate and looked to see whether I could identify any kind of a detrimental decrease in value based on proximity to surrounding properties.
And what was your conclusion
That this would not have any detrimental effect on surrounding properties
in terms of property values?
in terms of property values.
And this is all documented in your affidavit?
Yes.
Those are the questions I have, Mr. Chairman.
It looks like comparable site 2 could be argued to be closer in to the flight path, if you will. The rest of them don't seem to be as close. Did site 2 leave you any indications that the airport proximity was a detriment to the value?
No.
And I just heard someone back there that reminded me to check a box. Mr. Chairman, I'm tendering this witness as an expert in real estate appraisal.
Hearing no objections, so tendered. Thank you. Questions, Mr. Palmer?
Yeah, just speaking about the airport again, and I'm going to be referring to this several times. I'm looking at a navigation easement that was signed, and I'd like to know if your analysis included, and I'm reading from the easement, if your analysis included looking at the noise, vibrations, fumes, fear, interference with sleeper communication, illumination, deposits of dust and fuel particles, and other disturbances, if any of those things existed in the other properties you compared it to?
No.
So in spite of that, you don't think any of these things would affect the value?
No, my experience with properties that are around airports, with other things that I've done, there really is no detrimental value or detrimental reduction in value based on airports. What you're talking about there is beyond my scope.
Thank you.
And just for clarification, the question is, does the airport devalue the property or the reverse, that this project somehow devalues? I just want to be clear for the record what the question was.
The question is, I'm reading from the easement between the airport and somebody. I don't know who that somebody was, and I'm going to ask you.
It's not anybody connected to the property. There was a form presented early on in the process of communications, but there's not been a formal agreement with the airport. So you may be looking at a form.
Well, I'm looking at a specific legal document. There was an agreement between the airport and someone related to this project because it's part of the application.
Yeah, I'm not sure.
Is that included in the supplemental documents?
I think you've got,
It's the airport
It's in the-
proximate, it is, that there, we have it on our site, it's the, I'm assuming that what you're referring to
It's the thing that
is
looks like
the
this.
airport study, the airport advisory study, hold on.
And
Yeah,
Kurt,
no, this
this,
isn't a study, this is an easement.
Oh, the airport proximate,
this might be an example from another jurisdiction from prior types of projects. So nothing related to this application, an example of what a navigation easement has looked like in the past for other types of projects, is my understanding.
And we've got this, several windows pulled up with all these attachments and documents. Can you reference where this is found for the public and for us?
So within, Griffin, where would this be in their packet? I can tell you where it is on the website
Okay.
for the public. It's airport
Airport
proximity
proximity
study.
study.
It's about page 3 where that starts.
Yeah, I remember seeing that. I don't remember which document it was in.
I must say, Paul, I'm not really concerned about the airport proximity because there's so many residential places nearby, that are already dealing with the airport just being right there. And I know, like, my own personal home is on the is on the flight path.
Yeah, and I had the exact opposite feeling.
What does that mean? Do you feel it is a factor in that it will discount the property?
Well, I mean, I was going to start a discussion when we heard everybody's evidence and but since you asked, I grew up 6 miles from O'Hare, and every 5 or 10 minutes, an airplane either took off or landed, and we had to stop talking in my house every 5 or 10 minutes for the entire day. So I'm acutely familiar with living next to an airport.
I think we've got another witness, expert witness to come forward too, and of course the applicants. We have time to ask more questions about this particular document. But as far as the appraiser goes, any questions about this document or any others related to his work?
I think he did a good job on his comps. Nothing.
Hearing no others, sounds good. Thank you very much, Ms. Palmer.
Mr. Chairman, our last witness is James Vaso.
Thank you.
And just to let you know, Mr. Chairman, we should have David Roberts, who's representative of the property owner, connecting via the internet. So if there's any questions that require the property owner's input.
Okay.
James, good afternoon.
Please raise your right hand and state your name.
James Voso.
Do you swear or affirm to tell the truth and nothing but the truth?
Yes.
Thank you.
James, if you'll go ahead and introduce yourself to the board, please.
Sure thing. James Voso, Mattern Craig, 12 Broad Street, Asheville. I'm a traffic/transportation engineer with over 30 years of experience. I am a licensed professional engineer in the state of North Carolina. Graduated from NC State University, worked at NCDOT for about 11 years, and have been at Mattern Craig for the remainder of my career.
And James, have you prepared a written statement for the record before this board?
Yes, sir.
And what I've marked as Exhibit C, is that a copy of your written statement?
Yes, it is.
Mr. Chairman, I'd like to introduce Exhibit C into the record.
So admitted.
All right, James, if you will describe to the board what you did related to this project.
Okay, so we were hired to perform a traffic impact analysis on the subject property, subject development. We went through a three-step process with NCDOT, the first being a screening process to determine if the project actually meets thresholds for a study. That screening indicated that the project does not generate enough traffic to meet the NCDOT threshold of 3,000 trips per day. And it actually generates less than 100 trips per day, but it does meet Buncombe County's threshold because it's over 75 residential units. So because it's over 75 units, we did do a traffic impact analysis, and NCDOT had purview over that. The next step was to do a scoping of the project where we define the study area, define the growth rate to apply to traffic, perform the traffic counts, define the study intersection, so forth and so on. NCDOT reviewed and approved that scoping, and then we moved forward with the actual study, which is the third step of the process, where we complete the study and submit it for NCDOT review and approval. We did receive review and approval of the study from NCDOT. It's referred to as their final decision, where they approved the study and the recommendations in it.
And in terms of the recommendations, if you'll just touch on that with the board.
Yeah, sure. So basically, in summary, the driveway shall have 100 foot of internal protected stem length as a minimum. The driveway needs to provide adequate site distance per NCDOT's criteria. The driveway shall contain one ingress lane, one egress lane. The site will be served by a shared through left lane and a shared through right lane off of Glen Bridge. And that was all that NCDOT required.
And the applicant will be required to file for and submit a driveway permit application with the Department of Transportation, correct?
That is correct. So these improvements will be enforced through that driveway application process.
And based on your expertise and review of an analysis of this project, you drew some conclusions related to the Buncombe County standards. I believe they are contained within your affidavit, correct, in terms of whether the project
Yes.
would harm public health and safety and so forth?
That's correct.
And so the conclusions you set forth in the affidavit indicates that your opinion that the project would not be injurious to public health and safety and would otherwise meet the other standards of the Buncombe County ordinance as it relates to ingress and egress, correct?
That is correct.
Mr. Chairman, those are all the questions I have.
Board comments or questions on the traffic study or Mr. Russo?
None.
None. Hearing none, thank you so much. Appreciate it.
Mr. Chairman, those are our witnesses.
Okay. Did you have one additional remote witness or not?
We should have David Roberts via Zoom, simply if there's any questions.
Okay.
For example, if there was a condition, and I always say that we're open to any reasonable condition, but the property owner or the contract party is, and my client representative should be available via Zoom.
Okay. Sounds good. Anything else you want to say before we start to talk about this?
Well, I would like to do just a closing set of remarks, but I guess I'll wait until after you get through the next stage.
Sure. Does the board wish to hear from anybody else right now before we open public comment period?
Was there,
We'll then deliberate after that. We'll then have a closing statement after that, then deliberate.
okay, was there, clarify, someone here representing the airport or FAA that could talk further about that?
The applicant didn't bring anybody for that purpose. Craig, or,
There is an individual associated with the airport authority who is here to speak during the witness testimony.
okay, great. Yeah. We'll open that up then at this point. Yeah. We'll open public comment period for any witnesses who are here to speak. We'll ask for show of hands on this case. Anybody wants to speak for, okay, a few in the front row.
Or should we start with the individuals who contacted us?
Let's start with those, yeah.
Okay, because we have their names.
Before we do this,
so-
can I ask one
Yes.
question? I still haven't gotten an answer about this avignation easement, whether this is, even though it's part of the record, whether this is only a sample, in which case I have no idea why it's part of the record, or whether there is in fact an easement between the airport and some unknown party who's related to this.
Before we get to that public comment, then let's ask the applicant to clarify on that point. Anything to call somebody up?
There is no easement between the applicant or the property owner, the Huggins family, and the airport. In part because through the analysis, which you do have in the record from Jared's testimony, which the airport agrees with in terms of the analysis, there's not a issue that would have led to the parties needing to work anything more out. And so that was determined early on that we've done the analysis, there's not an issue. So we haven't pursued any type of agreement. So we have not entered into an agreement. I assume that the form you're looking at is some sample that maybe was offered up by staff, but
Yeah, it's in the airport proximity study document that we received as part of your submission on page 3 of 133.
okay. So that is
So-
just, that was a form that the airport provided as a sample that somebody else has done in a different county.
Okay.
So for clarity, Mr. Justice, you're telling us there's no easement here because there's none needed.
Correct.
Thank you.
Does that sort of address what your thought was? Okay. Thank you. Opening for public comment, we'll ask staff who submitted that witness application.
We'll begin with Jared Merrill.
Mr. Merrill. Welcome. You'll speak into the microphone and we'll swear you in first.
Please raise your right hand and state your name.
Jared Merrill.
Do you swear or affirm to tell the truth and nothing but the truth?
I do.
Thank you.
Welcome.
Yeah. Good afternoon. I am the Vice President of Planning for the Asheville Regional Airport. And I'll start by addressing, I'll start by addressing your question. The airport is here. I'm here to make the recommendation that a condition be put into this permit process. That condition is that the owner enters into an navigation easement with the airport as well as Buncombe County. That is why that document was put into that record. That is a sample. That is a sample from Henderson County. We've done these many times in Henderson County. We haven't done as many in Buncombe County. But we, as the airport, we have reviewed, and everything that Mr. DeRitter said is correct. The development is outside of the runway protection zone as well as the
Part 77, and it is for the future expansion. That did include, there is a 1,000-foot expansion to the north of the runway. And based on Mr. DeRitter's calculations, the development is outside of those protection zones and that protected airspace. However, it is still within the vicinity of the airspace, the federal airspace, and that is why we recommend the condition of the abrogation be put into place. The other issues that I would typically speak to on these things, because the project is within a 5-mile radius of the airport, the state actually requires certain stormwater measures be followed. They've already taken that into account in their design. They're planning for underground stormwater detention systems. The lighting, we always propose, which some of that is in the abrogation easement. Buncombe County's lighting requirements already cover any of those issues. No uplighting that would affect the safe operation of aircraft. So with that, I'll open it up to any other questions that you all may have in regards
So
to.
aside from the specified parameters that you mentioned earlier with relation to the runway and takeoff and landing areas, is there a set zone or perimeter that you usually ask developments or properties to enter into an abrogation agreement?
Yes, there is, and this one falls within that zone. The one that you're looking at was the Taproot project. It's actually a little bit closer than this project is going to be, and it is located on the south end of the runway.
Would that be like 3 miles or 5 miles? How would,
That one is located approximately, it's a little under 3/4 of a mile.
Okay.
From the south.
Speaking generally for all properties in relation to the airport's distance, how far would you usually recommend?
Yeah.
How far would you
It's
seek
usually
those?
within a mile to a mile and a half.
Within a mile and a half? Okay.
Mr. Chairman, I do actually have a question or two for this.
Let's get the boards done, then get to you. Okay, yeah. Question for the board?
Yeah, would it be fair to say that the easement that you're going to be seeking would pretty much mirror this?
Yes. Yes.
Okay, and would it be fair to say that this easement exists for the benefit of the airport?
In my opinion, it's in the benefit of the airport as well as the county, as well as the landowner.
But not the residents?
Yeah, I would say it is, because as part of that, we would recommend that the development include additional noise insulation. That would be another recommendation. The two recommendations that I put in to Mr. DeRitter as well as Mr. Blackwood that I met with several times is the execution of an abrogation easement as well as the recommendation of added noise insulation. That would be a benefit to the residents for sure.
Yeah, let me comment to the board that I'm really happy to hear about that second one. And we could do this later. I really, really recommend that we include those if we vote to approve this. Thank you.
No problem.
Thank you. Other questions? Yes, sir, Mr. Justice.
And I'm sorry, your last name?
Merrill.
Merrill. Mr. Merrill, the
Microphone, please.
the other examples you mentioned, Henderson County, the Taproot was the example?
Taproot Dairy, correct.
Did that Taproot fall, the location fall within the, you call it the flight path or the future projected flight path?
No.
It did not either?
No, because, and there's no extension planned for the south end of the runway. However, that one does fall within the range of the Part 77. They were, however, that one too was also in the direct, it was a much larger footprint than this development. So it was in the direct flight path. This one, I believe, is on a 10%, is somewhere around 10%, so not on the direct flight path.
So well, you agreed with the analysis that Jared had offered that we're not within any flight path, and we've taken into account any future plans you might have, right?
It is you're right, so it's outside the direct flight path, the direct alignment of the runway, let me be clear, but it is within that, still falls right under the airspace of the flight path for aircraft. So the aircraft don't just follow the runway, they circle the airport as well as go in the flight path of the runway.
So so in terms of the reason for this navigational servitude, can you tell me what is the reason for this?
It is to protect the federal airspace that surrounds the airport.
But you would
And,
agree.
and the activities that
Sure.
come along with being in that proximity of the airport.
But you agree that we don't violate, this project doesn't violate any federal standard, right?
No,
It
No.
doesn't violate any Buncombe County standard, right?
no, but these navigation easements are there to protect the airspace and the activities, as well as the airport and the county from the liability of the activities that go around in this proximity to the airport.
So let me ask you an example. So let's just assume, this is a document, I assume, that gets recorded?
Yes.
All right. So 22 years from now, the airport increases its airport traffic and has much larger aircraft and ultimately decides to continuously fly over, 22 years from now, over this project at whatever elevation that you want to fly at. And ultimately, the property owners for all times are signing off that they will not be able to complain or have any rights as it relates to the airport, right? Because it's a servitude, it's an easement.
It is an easement.
Yeah.
Yeah. So, to go into more detail, I mean, it really is for it's required for the safe passage of aircraft. There's certain things in there in that document that do put restrictions on things, on activities that can be done to make certain that the property doesn't do anything that makes it unsafe for the aircraft to pass through that area. But it also does point to the fact that there is noise, everybody knows that. It puts it all into writing so that everybody understands what they're getting themselves into.
You do understand that this project, one of the conditions of this project is we have to build what we are displaying on the material.
Correct,
Right.
absolutely.
And in terms of what we're saying we're going to build, that project does not in any way injure the airport. Planes will be able to fly. There's no safety issue about air traffic, correct, with these current planes?
Correct. I would agree with that. This just enforces that in the future as well.
Mr. Chairman, I would just say, with all due respect, I think the airport is a great thing to have an airport. But it's also a great thing that we have public entities providing water and sewer or transportation. And this would be no different if the DOT said, hey, board, can you include a provision that if we come through and we put a different route in for I-26, that you go ahead and condition that these folks will just waive whatever complaint they may be in the future. They give an easement across their property that will forever tie them to whatever plans the governmental agency may have. And you can imagine the slippery slope that would present if the city of Asheville showed up and said, hey, can you just tack on a condition to all your development approvals, or Buncombe County, or the state, in this case, it's the airport. And quite frankly, this has nothing to do with Buncombe County standards. This is a quasi-governmental entity with the power of condemnation, asking you to include a condition of record that basically there's an easement over this property in perpetuity to benefit the airport. And quite frankly, that is something outside of your standards and is not relevant, because we're not injuring anybody with our project. They just want to make sure that 22 years from now, nobody can complain about it. And that's not right. And you heard the witness say, it may actually require us to adjust our construction standards. again, you don't have construction standards that are tied to the airport. And what I heard this gentleman say, it might be a 1 mile radius, it might be a 5 mile radius that everybody has to sign off on these type of things. And it is not one of the standards that we can be held to. And with all due respect, I don't believe it's relevant, so I would have to object to the testimony and the request for a servitude across this property.
On the other side of that coin, you know, would a renter coming in to this project in the future expect a disclosure or something from the property management team that this is proximate to the airport and there will be noise? Is that something that you would envision that any future property manager at this property would disclose? It's obvious, but in some sense, but would you expect that disclosure for a renter coming in?
I've seen listing agreements. Beverly Hanks has a general standard that says you're going to live near things that cause noise. You know, the interstate may cause noise, but there is that general disclaimer. That is something that if you're interested in us doing as a disclosure, that's okay. But to actually allow the property to be condemned with an easement without payment of any compensation, so that if they basically fly over at 100 feet above our property years from now, that no one could complain about it, it's very bold, the ask, and it's well beyond the authority of this board. But if you're saying, hey, disclose to the folks that they're a mile or so away, there's an airport, I think that is a reasonable ask. Even that's not part of the standards, but that's at least a reasonable ask. And the reason I'm fighting so hard for this is I don't know what might happen years from now. Nobody does. And the case law is clear in this state dealing with airports, and I think this is the reason this gentleman's showing up. And all due respect, this is nothing personal. But the case law is clear that airports can cause property rights to be taken if they do unreasonably impact property. And the fact that we're showing up today wanting to develop property a mile or so away is not an opportunity now just to write basically a blank check for them to do whatever they want in the future. And this is with the evidence that the current plans of the airport are taken into account and the future plans.
So can I ask, if the board were to require is it 2 easements, one?
Just one
easement,
navigation.
which is more than this, because I didn't see anything about noise in this, so it's expansion of this. Would it be correct to say that if the board required that, you would not build the development? Is that what you're saying?
No, I would have to talk to my client about what I would perceive, with all due respect, to be an unlawful condition, and to see what we do about that.
I also do want to point out, just from a thing, if you require them to enter an easement, both of the parties are going to theoretically have to agree to enter into the easement. And I don't know whether you're going to, I don't know what to do if they don't agree, right? You're saying as a condition, you have to enter into some kind of easement with the airport. Well, the parties will negotiate that. They may agree, they may not. But from an enforceability standpoint, that would be very difficult on staff. So I think you need to be very careful about what you're requiring. Now, I don't like the noise insulation and noise warnings. I think that's very different, but requiring somebody to grant an easement to someone else, I have to agree with Mr. Justice that I don't think that that's really within the board's purview, and that's not something that the board should be getting in the middle of.
Can I address just a couple things? Number one, this is not just to protect the airport from complaints. These navigation easements are done to also protect the county from future complaints, because we're going to go on the record, whether you decide to do it or not. We're going to go on the record, and that's what I'm here for, is to say that this should be a requirement. And that's the reason I'm here. it should be a requirement not only to protect us, but to protect the county. And that's one of the reasons why Henderson County has entered into so many of these agreements with us. You mentioned 1,000 to 5,000. The 5,000 is only for the stormwater requirements, not the navigations. But I just wanted to kind of jump in there. And again, these are the two things that I sent to Mr. DeRitter in writing that we've remained adamant. It's not something new, and I included that sample. I'm not sure why you didn't get a sample of that, or that document, since it was entered into the documents, but that is a sample. My two recommendations was the avigation easements as well as the additional noise insulation.
So, since the airport's been there, for properties who've been approved and built since that's happened, what's the consequence, or what happens when you don't get one, so the aviation agreement secured?
That's simply what I'm doing here today. The airport is going on the record, asking for this recommendation, asking for this condition to be put in prior to the permit being issued, and Mr. Justice is right. Our legal counsel would work with him to develop that avigation easement and to be agreeable to all the parties, and we would basically submit that with the permitting process.
Well, let me ask you this. What if the parties don't agree on the easement? What do we do then?
So I haven't seen that happen. I've been at the airport over 5 years now. I haven't seen that happen. Ultimately, I would assume that we would just go on the record stating that we went through this process, but we couldn't reach an agreement.
How many times have you appeared in front of this board asking for this?
This is my first time in front of this board.
Does Biltmore Park
It doesn't mean
have-
that the airport has not presented to this board before on this
Okay.
issue.
Joel, you have a comment?
On my first comment, no disrespect your example about us setting conditions about I-26. This is out of the purview of this board. We can't consider state highways, we can't consider interstate system. Now, regarding the witness here from the airport, there's a comment about O'Hare Airport. I have a comment regarding Midway Airport, where airplanes have slidden off the runway into residential areas, and especially if there's expansion. So one of the things we can take account, and forget the noise, one of the things we can take account is public safety. Would this application easement, in your opinion, also be a public safety issue?
Yes. Yeah, absolutely.
In terms of what, Mr. Chairman? In terms of what as a public safety? Because the example given was an airplane sliding off the airport runway.
You're right, yeah.
So be very clear when you say it's a public safety issue, because you have agreed with our analysis.
Correct.
That it's not a public safety issue.
Right.
You're just asking for an exaction.
I want to be clear here on the protocol, and obviously we have a witness here to make comments, and an opportunity for the council to, make comments after that, but it's not a back and forth, and so we want to make sure we respect the witness's ability to testify and to make their comments known. But if the witness would like to elaborate on that, that'd be great.
I'm sorry. Well,
on the public safety element of
so
the aviation.
on the public safety, I was simply agreeing with you. Just my interpretation of public safety is to enter into the avigation easement and the items that are included in that document. I don't believe you're correct, Mr. Justice. I don't believe there's any safety issue as far as an aircraft running off the runway and impacting this area. However, it is within the close proximity of the airport. And let's be clear, things happen within closer proximity to the airport rather than further away. But I'm speaking public safety. When I agree with you, I'm simply stating that to cover our basis, the avigation easement's required. I don't foresee that something's going to slide off the runway and impact this project in one way.
Okay, can I ask?
Before you
Can I
do
ask a
that, we
quick
have
question?
one over here.
In your 5 years of being at the Asheville Airport, how many of these have you asked for and then attained?
2 in my time in Henderson County.
But what about for Buncombe County?
Not for Buncombe County. This is the first one for Buncombe County.
But how many people have you guys gone after to ask for this?
None, and not since I've been there in Buncombe County,
So why are you starting now?
because this project falls.
Because they're a
within that
mile from
area.
the airport.
Yeah, this project falls within that.
Questions and answers this way. Yeah,
Okay.
Thank you.
And then why didn't the airport authority go to the Buncombe County Master Plan and be part of that process if they wanted to get this in there?
So we work directly with the zoning department. We're very familiar with the master plan process. There wouldn't be anything that we would put in the master plan to say all these areas require navigation easements. It wouldn't be something that's typically, there is an entire section about the proximity of the airport in the comprehensive master plan for the zoning. And we agree with basically everything that's put into that. But with regards to navigation easements, that's not typically put into the comprehensive master plan for the counties.
Joel has something?
Yeah, what would be the cost to the developer if you did agree to this obligation easement?
How does one project the cost in the future when one doesn't know what the airport may do? Literally, I presume that if an airplane negligently crashed into our property, we wouldn't even have a claim in that instance. And so the easement is so broad as a release, it's hard to quantify cost. I can tell you that these noise insulation standards, that may be quantifiable, but I'm not prepared to tell you what that is. But again, I guess going back to Ms. Morisani's point, the law of the county and your leaders is what is in your ordinance. And if this was such an issue deserving of a standard, it would be written in your code. And you don't have that. And there's no evidence before you that this project is causing any harm.
Yeah, can I make a comment on the question?
Please.
First of all, let me say that you don't know that the easement is broad because you haven't negotiated the easement yet. And I will ask the gentleman from the airport, I'm going to read two legal phrases, okay? Would you say that the lack of the existence of an easement either adversely affects the health and safety of the residents or is detrimental to the public welfare?
The lack of the easement?
Yes.
Yeah.
While I understand your question, I do not believe that the witness has even been qualified to answer that question as an expert. I think what we need to be, you're asking for a professional opinion on public safety. I'm not sure that anything's been established to where the witness can make that statement. So I just want to be sure if you want to ask him
Well, he can
some
ask him-
questions about his bona fides
Right.
and try to get there. But I think you know that's
Or the
not
airport's
really.
or the airport's position on that issue,
Yeah,
but not a legal interpretation.
Yeah, I don't want him, if he's giving an expert opinion, once again, that the expert needs to be established before an expert opinion is given.
And even a position is an opinion, unless they're qualified as an expert. So it would have no competency under our law. But I'll ask, do you have any qualifications relating to the residents of the project in question?
So-
Related to noise or anything like that?
So I have my bachelor's degree in construction management. That's my expertise, and that's why I'm in charge of planning at the airport. So no, listen, I'm not a legal advice person. I'm in charge of planning for the airport, and these are the agreements that are, that we put forth on projects within this vicinity and in this nature. And that's my response to
But that's, he's qualified to relay the airport's position.
Correct.
These items.
Correct, absolutely.
What's the time horizon that you are planning for when you're in the role of planning for the airport? How far out are
So,
you looking?
yeah, so we just finished our master plan, we're finishing our master plan process right now, and the 1,000-foot extension is for the next 20 years. It is planned for within the next 20 years. So that's what each year we're planning 20 years out, essentially.
And there's no plans that beyond that at this point in time?
No, sir.
But as I gather, this is attempting not to rule out that at some time in the future, 50 years from now, someone may want to say, we're going to double the size of the airport runway. And this document that we're discussing is something that we want to try to put in place to mitigate any concerns about doubling the size of the runway. If we don't approve it, then at least you've done your job and put it forth to this committee to render an
Yeah.
opinion.
And in this case, I wouldn't even say it's doubling, the
I just
runway.
picked it- I just
Right.
exaggerated.
I wouldn't even say it's 50 years out. These easements exist for the way that we operate today. Yes, it does help for future development, but it's essential for the way we operate today and the safe passage of aircraft in this area today. So,
Mr. Chair, can I ask you a question? I'm obviously sort of narrowly hung up on this particular issue. Am I allowed to ask the gentleman from the airport if, to the best of his knowledge, the airport has an opinion on adversely affecting health and safety or detrimental public welfare? Is that a question I can ask him?
Kurt?
I think Kurt said he's not qualified to answer that.
Well, he's qualified to answer if the airport has an opinion. Somebody said that.
I would think that if the airport had an official opinion on that, once again, when you're getting into giving, me saying that there is a public safety threat, that doesn't, I'm not qualified to give that. I don't think the witness that you have here is qualified, and I think anything that the witness says on behalf of the airport would possibly be hearsay.
Well,
And
Kurt,
so I think that if the airport had a public safety, they would need to present somebody here that's qualified to give that opinion. If that makes sense. That would be my advice, that if the airport,
we can't take it as expert opinion. We can take it as lay opinion.
so
but unfortunately, I'm not sure the law allows you to take it as lay opinion. Because, it's no different than a citizen coming up here and saying, the road's not, too narrow and it's going to cause a bunch of accidents. Yes, they can get up and say that, but that's not something you're supposed to consider. Now, that's very different if a traffic engineer gets up there and testifies to the condition of the road. So
in this example that we're going through here and live, does an attorney from the airport need to come and make this statement?
I don't think an attorney
Who would
needs to come to airport. I think somebody
not
that
the
is
planning director.
qualified as an expert in determining, airport safety and distances to that. I don't know.
I will say this, if this project were within the runway protection zone, which it is not within the runway protection zone, which extends 2,500 feet to the north of the runway. I would be here under different circumstances, recommending, completely disapproving this project and having residential be put into a runway protection zone. We're clear of that, and Mr. DeRitter's plans have shown that. So for us, the avigations easement is just that next step. That's the only thing that we're asking for. If it were within that runway protection zone or interfering with our Part 77, I would be here under vastly different circumstances in recommending that you not move forward with the approval of putting residential in this area. However, it is outside those parameters.
Mr. Chair, I've got a question for the witness. Mr. Merrill, so I'm reading through this example easement here. Just for clarity's sake, you know, we're talking Henderson County, Buncombe County. It appears from the language in this easement, this was conditioned on a rezoning process,
That
which is
one
a
in
legislative
particular.
process.
Yeah, that one
Not a,
in
not a
particular.
quasi-judicial approval.
Right.
Correct?
That one in
Okay, so
particular
that-
had.
That's a
that-
very different process.
Right.
Right, okay, just for clarity, because we're bound by very black and white rules. We're not, we can't do the popularity contest with this approval. Okay, just for clarity.
Now,
Thank you.
we would, obviously, that verbiage would change as to what this permit application is for, just to be clear, but you're right, that one was a rezoning application.
So, Mr. Chair, I don't think this witness and this aviation easement is in our purview, and I don't think we're the right group to do it, and I don't think it is a party of this situation, and I think we need to just move on to a different witness.
I think we've heard from council that exact same thing, that we have no say, cannot enforce, cannot chase an agreement between other parties.
Once
for-
again, as legal counsel, I'm giving you advice.
Right.
Right? You know, obviously you can take it. You could not take it. That's
I'm
what
comfortable
advice
taking it in
is.
this matter.
But
Comfortable
I,
taking
you
it.
know,
Can I
so
make a
thank you.
motion that we close out this witness's conversation and move on to our next witness?
Let's give the witness any opportunity they want to say anything else, not related to this, and then we'll go ahead and go to the next witness. Okay, let's do that. Joel, is it a question for the witness? Let's wait till that. Any other comments about
No.
anything? Thank you so much for being here. We
Thank
appreciate
you.
it.
I appreciate your time.
Thank you. Next witness.
Wanda Radcliffe? Wanda Radcliffe? No. Alex Leatherwood?
Welcome, sir. If you'll speak into the mic, and we'll swear you in first.
Welcome you, thank you.
Please raise your right hand and state your name.
Alex Leatherwood.
Do you swear or affirm to tell the truth and nothing but the truth?
Yes, sir.
Thank you.
Thanks for being here.
Thank you. So I own track that borders directly behind where the bottleneck is between the 25 acres that they're purchasing. Then there's a bottleneck, so I could roll a bowling ball to the bottleneck. So, you know, we understand when we bought that property, and I don't know, you said talk facts. I'm not a land expert, nor do we, the six of us that own property borders this. We have not had time to seek any advice, professional advice, expert advice, legal advice. We had a card come in the mail 2 weeks ago. I didn't even get mine. It went to another address. And so we've, you know, and we know this is probably, you know, it's rated EMP, it's commercial. We've known the land's been for sale for a long time. We've all tried to find a way to protect our investment that we have against what's coming now. We have tried to find people to buy it, to subdivide it like our development is, 3 acres per lot. And we have not been able to do that. It's an expensive piece of property. It's hard to get to. They do have a right-of-way off of Glenbridge Road instead of using the church property, but they've worked it out with the church to do that. And so we are concerned about, you know, several things. And we've had about 6-7 days to figure this out. So, and I'm not real professional on what this meeting is about. It's approving this, but, you know, we definitely need more time for us to get some advice. And I know it's in good faith. They're probably, this man's very legally knowledged. So is everyone that spoke here. So we need some time to make sure that we're protected, make sure that we have enough greenway. And from the drawing that they put up, the building is back. They have done that well. Everything looks good. You know, but there's a lot of other things. You know, there's a bottleneck behind my house that if they put traffic through there, what's coming in the future? I mean, I can roll a bowling ball over there to hit this place. And As far as, you know, we have some concerns. The water, it's very wet back there. My house floods right now behind my house some because when it starts raining hard. There's a lake down on the other side that me and that neighbor's had falling outs 3 or 4 times over the amount of water that comes off our property. There's wildlife back there. There's all kinds of deer. And, you know, we were hoping that, like, again, that this would be sold to, you know, a neighborhood of small houses, not 183 apartments, but it is what it is. They have dual hunting. I'm not real familiar. I don't hunt, but they have dual hunting back and forth, you know, to protect these deer from getting on the airport. This is going to push them out. As far as airplanes, if you want to see how many, and I got a question for him. How many planes fly over this project in a day's time?
We can't really unfortunately do it back and forth. This is your opportunity to make comments to the
Okay.
board, and the board and
All right.
anybody, and the applicant can then respond later on, yeah, if they
Okay.
want to.
Well, I live there, and just to give you a little quick example, my son's name's Jet Leatherwood, and the reason his name's Jet, because me and my wife were laying in bed one night, about 11:30 at night, and an F-16 came over. It felt like it's 20 feet over my house and scared the crap out of us. So my son was going to be named Cruz, or we thought about Cruz, and I thought, well, that's not a good name to have in school. And when the jet flew over, we both looked at each other and said Jet. So there's probably, and it's loud, but we accept it, we deal with it, we're private individuals. I can tell you when 183 people live in that apartment, y'all are gonna get phone calls. But as far as dangerous, I mean, nothing's gonna come off the end of the airport and hit anything, it's gonna go in the river. But there was a plane crash, you know, down at our mailboxes, a Cessna, probably 15 years ago. So it is a concern. We haven't even thought about that concern. We're just concerned with protecting what we have. I knew David's daddy when he was alive, great man. I helped him do some things that he needed. He told me one day if I ever needed any land, you know, we had a good relationship. Unfortunately, he passed. David's got to do what he's got to do with the property, and has tried for a long time to sell the property. And now they've come in to do this. So we need, I mean, we got a letter, a card 2 weeks ago. Didn't receive any of this kind of stuff. And then the property address is Sumner Drive, 101 Sumner Drive, which is what we live on. There was no sign on Sumner Drive. There's a sign on Glenbridge Road that wasn't there, but it appeared 2 days ago. So we haven't had enough time, not that we can stop it, but we need to protect what we do have. So he's an expert. He sounds like an expert. I'm an expert in the car business. The man that's a land expert said that this community of 183 apartments is not going to affect 6 $1.5 million pieces of property. I think he's confused, because it will. And, you know, because it's right there. So, you know, we just need some time to be able to get some stuff together, and I don't know what decisions are going to be made today, but that's just, you know, basically all I have to say. There's a few other things, but it took so long, we didn't get, so the picture that you first put up with the 183 apartments, the road comes around to the back of it, is that, and he said that they were gonna preserve the rest of it. Is this all that's gonna happen, or is this level 1 of multi-level?
Yeah, we'll have an opportunity for the applicant to respond to those questions later on, yeah,
Okay.
in our process. We appreciate it, though. Thank you very much.
All right.
Yeah. Any other witnesses that let us know they were coming in advance?
I'm not sure if David Huggins is still here. Are you wishing to speak? No, okay.
Anyone else here to speak as a witness? Please.
Please raise your right hand and state your name.
Stacy Brown.
Do you swear or affirm to tell the truth and nothing but the truth?
Yes.
Thank you.
Welcome.
Thank you. This has been a very interesting process. Thank you for welcoming us in. I also am Alex's neighbor, and I border where the building is going to be. So again, I want to reiterate, we got a card 2 weeks ago. There's been nothing else posted. At that time, I got immediately on the computer. That is the first time we've ever seen any of these plans for development, which that's probably how it works. So I spoke to Griffin and expressed that, you know, we do know that this is just part of growth and all the things, but the situation where we live is very different than, like, say, if you're backing up to like Mallard Run or Biltmore Park or somewhere like that. There are literally like 6 of us that this affects, because we all have at least 7 acres. And so we don't even have the depth of people to get up here and say, hey, you know, we are concerned for these reasons or whatever. So in turn, we really do feel like we need more information. We need legal representation on our end to make sure that we're getting the same experts to look at things where we have concerns and provide us information to see whether it's within the parameters or not, because we're only getting one side of expert testimony. So what we would like to ask for and have you all consider is a continuance in this, because we feel like we do have a lot of questions that we need to have answered and provide you guys with any information that might really impact the future of our land. Alex addressed the water situation, which I'm just gonna bring up again. I know they have done water studies on the property that they are purchasing, but the way it falls, we are on a watershed on each side of our house that goes into this same pond. And if it's not done really, really well, we could, you know, suffer greatly from any runoff from this, because the project is taking place above a hill above our home. So it's not flat land, it's up a big hill. When they're saying the 200 feet they're giving, well, that's because it's a hill. So we have some serious concerns that we would like to have an expert come out and have us look, you know, take a look at those and how that might affect us. So really, we're just asking that you guys consider the timeliness of this. We were not given much notification or much information on the plans, and we would like to take some time to look at that on our end to make sure we do protect our multi-million-dollar homes that's really our biggest asset in our lives, you know? And I know people can look at numbers and say, oh, it's not gonna affect you, you'll be fine. But if you came and saw the property and the way it's laid out, I will be literally looking at this apartment complex with its lights. I mean, it will change everything about where I live. And I get it, it's progress, but I hope we can all agree that we wanna do it as best as possible for the current residents as well as the future people that live there. And to the airplane thing, if anybody wants to take a little gander with the airplanes, come on out, because we live right there. A lot of people say they live near the airport, but we live in the landing and the takeoff path. And they fly, I mean, I have to put the phone down if I'm talking out in my house. And I'm used to it, but I agreed to, when we bought our land, my husband, Wally, we were thinking about buying the land back almost 20 years ago. And I said, well, you gotta go out there and listen for the planes, like at all hours of the night. And he would go and camp on Alex's land and listen to see if it was worth us buying. We agreed to buy it, but that was, again, almost 20 years ago. And the traffic is greatly different, and the military traffic is huge. And so if you don't think there's fighter planes, you're crazy. They go over several times a week. So anyway, we appreciate you letting us talk, but we really would like to be considered in this whole situation, to have a voice and collect some information and meet again.
Thank you very much. Any questions? No? Okay, thank you. Oh, sorry, Joel?
I believe that staff did testify that this was properly noticed, but I think that was staff, so Shannon, I'm assuming we properly notified.
I can provide information about the process that we use to notify, if that would be helpful. It's the same for every type of application.
Was there anything posted on Sumner Drive, since that's the address of the project?
Did you do the posting, or do you know who did?
I didn't do the posting, no. Our code enforcement team posts these signs for us. They post them, they're required to
Dana,
post
I think we
them.
need to swear you in, because I think this would be considered testimony. So please raise your right hand and state your name.
Dana Alley?
Do you swear or affirm to tell the truth and nothing but the truth?
Yes.
Thank you.
We're required to post the signs where they're going to be seen most often. So that's why it's down there on Glen Bridge. It's where the most traffic is coming by.
Was it on Glen Bridge at the entrance of Sumner Drive? Because that's the address.
That's the address, right on
Yes.
That's the only way we would see it, is what I'm saying.
And just
Nobody else cares about it.
for context, typically when we post the signs, we post them at entrances of proposed development. We don't go to other kind of areas of a property and put out signs if there's not any proposed entrances onto the land from there.
That's why it's doubled up. That's why it's doubled up with the mailings that you get directly, and that's your notice. So right then you start to call if you have
That was 2
issues.
weeks ago, and the sign that
That's
they
right.
posted was not there. It may have been there, but it was not there. It was not there all last week. It got put there 2 days ago.
On Glenbridge?
On the entrance of the church. It was put there 2 days ago. Now, it may have been put there before, but there was a big tree. Ooh, there was a big tree that fell. Maybe it took it out. I don't know, but this is the first time. And, you know, I have talked to David on the phone because we heard the land was for sale. Dan keeps up with all that. But he didn't want to talk about it, obviously, because he didn't want no interruptions. And I get it. You know, he's tried diligently to sell the property, and if it was my property, I'd feel the same way. But 2 weeks ago, we got a little card. I have it in my pocket. And that's all we've had. So obviously, I have a 5 acres and $1.5 million house. They all have it. It took me 20 years to pay for it. Anyone to say that this project is going to not diminish the value of our home is not an expert.
So we didn't get you with the sign necessarily, but we did get you with the mailer. Is that right? 2 weeks ago?
2 weeks ago, yeah.
Okay.
But I
That's the
didn't
procedure.
get mine. It went to another house. So
Goes
I
off the
found-
tax card, goes off
Yeah.
your,
Yeah.
public address.
Yeah, but
So-
anyway, we haven't had ample time, and 2 weeks isn't ample time either, you know, so.
We've got an ordinance on this and requirements that we stick to heavily, and we've got testimony that we trust right now saying that the proper measures were taken. We can't, the board has no way to know if a sign was placed a certain place by the required date and then stay there the whole time, obviously. That's why we duplicate efforts. So, thank you.
So is the mailer was only supposed to it was legally supposed to go out 2 weeks ago? Is that when it was supposed to? Not a month or two?
So there is a window, a legal window within which the notices have to be mailed. I can't remember.
I think we're starting to go down a road where we're having a lot of conversation that's not really testimony. I believe that if, so I think we need to be careful. Obviously, we want to try to answer questions, but you know, none of these parties that have spoke have applied for standing or have standing. So, you know, they can give their witness statement, and I think we've been more than accommodating and answering questions. But, you know, if somebody has a problem with how we're noticing, you know, obviously they can change, that can be changed, but that needs to be changed in the ordinance.
That's right, yeah.
Okay.
And if the board is fine with that testimony, that we have a procedure that's been followed, then we're fine from here. Next witness. Thank you. Thank you, sir. We appreciate you. Next witness. Sorry, there was a third hand from the gentleman in the striped blue, and if he wants to say something.
I hate getting in front of people's up.
Please raise your right hand and state your name.
Ollie Brown.
Do you swear or affirm to tell the truth and nothing but the truth?
Yes, I do.
Thank you.
This is basically just an observation that well, not even an observation, it's a fact that I just want to make the board aware of. So that whole area, all of our houses, I think it goes all the way to the Parkway, but it's a wildlife easement corridor, and it was put in place by the North Carolina Wildlife Resources in conjunction with the airport for the safety of the airport. And so the more developments that go in that corridor, which this piece of property is right in the middle of the corridor, it's going to potentially be safety issues for the airport and all the residents around. And so there's different hunting regulations that corridor has. And so if you take more land, more easement, more of the corridor, it's going to be a problem. So I just want to make the board aware of that.
Okay, thank you so much for that.
Yep.
Any other parties here wishing to speak as a witness? I don't see other hands, but I can't see behind the TV, so I don't see any more right now. Going once, going twice. Thank you. We'll ask Mr. Justice if he has a response to anything or if he wants to do a closing statement.
Well, I have a response and a closing statement. I didn't object to a number of the comments. You heard that that expert is really not an expert. I think my property values would be impacted. Of course, state law requires an expert. You have accepted our expert, and so that's what the record shows is not an injurious impact. So for whatever it's worth, I, of course, have to object to certain comments that were made.
No, the public hearing has been closed. Thank you.
Mr. Chairman, this is a great example of why we have the rule of law. Your county commissioners, the leaders of this county, made the law relating to what you were to look at with this permit. In doing that, they also made important decisions like the zoning of this property EMP, right? Which allows 12 units an acre, and we're well under that. We're well exceeding open space requirements. So to the concerns expressed about how far off buildings might be and how much open space, the plan is, as a condition of this, what we're supposed to develop, which far exceeds setback requirements, which far exceeds open space requirements. As for erosion control, y'all regulate the heck out of that, and that's in front of us in terms of erosion control plans and mandate from the state and the local government to comply with those. Stormwater, we will meet all your stormwater standards. You heard from the only experts in the record here of compliance with all the standards. This is a good case of the rule of law, because I don't disparage anybody who's a neighbor to anything that's going to change, saying, I've got concerns, I have issues with this. I think we all would like that property remain static next to us and don't ever change. But that's not the reality. It's not fair to the Huggins family. I think the reality was everybody's known this property has been zoned EMP. And that's not the law that says your neighbor can't develop this property in accordance with standards. And that gets to my point about the airport. I love the airport. Airport's great. But again, the rule of law here for this permit is not for you to say, well, the airport wants a waiver or a release for anything that may happen in the future for property within a 1 mile radius, and asking you to be the board to impose that upon development. That's not a standard. The testimony is we're not impacting negatively the airport in the operation. I would hazard to say that not one boardroom meeting will take place where they say, you know, that project down the road, we didn't get that agreement signed, let's not put in this runway. Do you think really that's going to happen? The reality is, if they put in a runway or they change airplanes and make them bigger and they fly more, nothing we do will stop that. We're not hurting the airport. But they're asking you to give in perpetuity the right of a property owner 20 years from now to say they did change their flight paths and they're flying 100 feet above us, and a lot of it, to say we do have an issue with the airport in the sense of there's a property right and we can deal with compensation later. Because that's normally what happens with government, is they negatively impact you, they then pay for that. They don't show up at boards like this and ask you to give them a blank check. So with all due respect to the airport, none of that was relevant. We have met the rule of law, which is the standards that are in your ordinance, and the only evidence of that are our witnesses. And one may say, well, why don't you just go along with this condition? And again, the problem with saying just give a servitude to a government entity, we don't know what impact that may be 5 years from now, 10 years from now, 15 years from now. And to impose an easement over our property is I think, unreasonable. So with all due respect, we do believe we've met the standards. I've been through a number of these with y'all, and we have checked the boxes. we ask that you go ahead and approve this. The only condition that was a question that the staff read off was we will own the driveway, meaning that will be our land. So in terms of the church will have rights to it. So in terms of providing to the staff a copy of the church ability to use the driveway in an agreement, we will provide that, just to clarify that one condition. But we would ask that you go ahead and approve this project today. Thank you.
Thank you very much. Public hearing and the testimony is closed and open for board discussion and deliberation.
Okay, so Andy,
Oh, I'm sorry. I'm sorry, what? He has an opportunity to answer questions, but it's not requirements. It's a public comment period, it's a witness period, that kind of thing. And you don't necessarily have a back and forth or, a requirement that he answer. And we've gone through the whole hearing at this point, so we've got to deliberate on that at this point. We actually have closed the public hearing part, but we did have time for you to be up here and ask your questions, so we have had that time. Oh, no, I didn't say you would. Said he didn't get an opportunity to answer if he wanted to.
And there's also the possibility of speaking with the applicant or their representatives after the conclusion of the meeting.
Or before today, yeah.
so,
Sorry, we have to ask the galley just cease other discussion. If they have discussions, they can take them outside.
Andy, can I
Yes.
start?
Yes.
I think this project is well done, well thought out. It meets all of our criteria. I hear Paul's conversation about the airport. I live on I live on the pathway to, when I bought my house, they said you are on the pathway, the air pathway. I think this project is a really good one. It's needed, it's EMP zoned. I think it meets all of the criteria that we would want for a project.
And while, let's get Joel in first, I'm sorry.
Yeah, I've got some comments. I know I brought this up before. If this obligation easement is granted, what would be the cost? And all I'm hearing, it's a cost. So when we look at hardships, okay, for me personally, I'd like some hard facts, what the cost would be. The other issues I have, again, dealing with the airport. We're not talking about four-seaters, we're talking about 737, something I totally forgot. Someone brought up F-16s, okay? They're a little bit different. Now, I'm not concerned about noise. I would just hope the management would tell the residents, you're gonna hear airplanes, and let it, go at this. I'm not concerned about noise. Now, as you're saying, someone from the airport came here, he's a layman, not an expert, okay? This board's allowed to take into account public safety. I mean, that was the issue too regarding a landing strip in Sandy Mush not too long ago, where the person would have to land and take off, make a sharp right turn, rather than going over local farms, okay? I'm looking at public safety. For me, I see nothing wrong with development itself, but for me, and when I say public safety, the public are those that are living on the ground and in the aircraft. I would like to see an expert come here, because I can't really support the project to ensure it's gonna be safe for everyone. So that's and the other question, maybe this is for Kurt, it came up that possibly this creates a liability issue for the county. If that's the case, what's the county's, feedback on this?
Well, I can only speak as a county attorney, and at this point in time, I am not aware of any liability to the county regarding this project or any possible interference with the airport. I would think that if there is any issues with the project, and if there's something with federal law, the FAA will let us know in short order. So I am not aware of any county liability. Once again, yes, this is by the airport, and if somebody moves into an apartment that's near the airport, obviously we will take their complaints, but, short of, I don't see where the county or the taxpayers would have to pay any money for doing something wrong.
I think it's important to note that the airport representative said if this was in the flight path, that he would be here on a very different mission, and it's not. So that cleared that concern in my mind when the gentleman from the airport said, if this were in the flight path.
There is no opportunity for further public comment at this time, so all outbursts have to cease. Thank you. Greg?
Yeah,
I just, like I said, I mean, the gentleman stated, if this was in a different location at the airport, I would be here in a much different capacity, and he is not here in that capacity. I also think it's worth noting that while not part of the decision-making process, this is zoned employment, and there are a lot of, I would think, very offensive things that could go there that would not have shown up at this hearing.
Incinerators.
Mr. Chair, if I may.
Yeah.
Go ahead, Gabe.
Oh, sorry, I didn't hear you
That's
say.
right. I just my commentary, I think the project overall is well thought out. It's a good use it's a pragmatic use of the land. It is within the confines and in the by rights of the current zoning. We continue to find new and interesting rabbit holes in cases we hear. I think what I see from the expert testimony and the documents we've been provided, the public health and safety as it relates to the airport airspace has been met. The additional, I guess, curveball conversation is an ask that it really is not in our legal purview, as the Buncombe County ordinance clearly states in black and white what we're here to do. So in that regard, I can support the development moving forward.
I just want to make a note. We talked a little bit about, back and forth about the playground, and it is noted on the site map. So I want to make sure when we get to the point of an order that that language is in there as a condition as well, as it usually is. So, Craig.
Gabe, I appreciate your comments. I joked with the attorney that we're killing a lot of trees, and have we not seen this before? I came in here having reviewed this material, and I concurred that I was looking for where are they missing something? Where are they failing the tests that we have as a part of our evaluation? And I didn't find where they failed the test. It's a very thoroughly thought through, documented. We had the expert witnesses here to answer the questions that should be posed during that period of time. Now is not the time to pose additional questions. It's to take what testimony has been presented by the experts, look at what documents that we have on the record, and determine, is there anything here, according to the laws, according to what we are supposed to pass judgment on, that causes question, and I have not seen any. That is not to dismiss the what we've heard from the public. Fully understand and appreciate the challenges that this development may pose to them, but we've looked at everything that we can and taken into account all of the testimony and the evidence, and I see no reason why I would not support this project.
Any other comments? Seeing none, we're open for a motion.
Mr. Chair, based upon the evidence presented to this board, including the following exhibits: the petitioner's application, the submitted development plan, the GIS maps, the staff report, testimony presented at the hearing, and I think the playground, the addition of the playground, I've forgotten what that word is. Yeah.
Yeah, that's right.
I move that this board adopt the following findings of fact: that this matter was properly advertised and is within the board's jurisdiction and is ripe for consideration, that this application, together with the conditions proposed by the staff and/or this board and agreed to by the applicant, if any, does meet the requirements for granting the special use permit contained in Buncombe County
There's been a motion on findings of fact. Is there a second to that motion?
Second.
Hearing a motion and a second, all those in favor, please say aye.
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 Any opposed, nay? Hearing none. Second motion?
Based on the foregoing findings of fact and for the reasons set forth therein, I move that the requested special use permit be approved and that the order approving the permit be adopted and executed as presented and modified in this meeting.
There's been an approval motion. Is there a second?
Second.
Hearing a motion and a second, all those in favor, please say aye.
Aye.
Any opposed, nay? By a 6-1 vote, that does pass. Thank you very much. We'll ask staff when they're ready to approach with an order to read and that point, okay.
I'm just going to go, I know that this probably took a little bit of time. So the findings of fact, that this is an applicant for an SU, I'm sorry, that this is a application for a special use permit pursuant to section 78-641 and 78-677 and 78-678 of the Buncombe County Code of Ordinances for a 180-unit multifamily residential unit, that the PUD, that the property will be under single ownership by final approval, that the density is consistent with the ordinance, that the land uses are compatible with the intent of the zoning district, that the proposed land use meets the minimum requirements for land development, the minimum lot sizes, and requirements for interior setbacks do preserve the spirit and intent of the zoning ordinance. The proposed heights does comply with the spirit and intent of the ordinance, and the board finds that the maximum distance between buildings will ensure adequate air, light, privacy, and space for emergency vehicles, that the development does provide reasonable visual and acoustical privacy for all dwelling units. The structures will be located on the perimeter of the development, will be set back from the property lines. The board finds that the proposed parking does comply with the spirit and intent of the ordinance, that the maintenance of the open space recreational areas and owned and communally owned facilities are in accordance with the general statutes. The board finds that the building envelopes are shown on the site plaque and depict the maximum expansed and proposed footprint of the structure, that pursuant to 78-677G, the proposed use will not adversely affect the health or safety of persons regarding or working in the neighborhood. The proposed use will not be detrimental to the public welfare or injurious to the public, injurious to property or public improvements in the neighborhood. The proposed use will not cause or have an adverse effect on the surrounding properties due to noise, vibration, odor, or glare effects. Satisfactory ingress and egress to the proposed use has been provided. The provisions for off-street parking have been arranged for. The provisions for adequate and proper utilities have been arranged for. The provisions for buffering have been arranged for. Signs are in harmony with the property in the district. Playgrounds, open yards, open spaces have been arranged for. The buildings and structures with reference to location, size, and use are acceptable. Home hours of operation, in particular to maintaining the character of the neighborhood, are acceptable. The following conditions, really it's basically the county standard conditions. The only thing that we added was the applicant must submit a cross-access agreement or opinion of title for access to the property through the adjacent parcel of land.
So we would provide the cross-access easement with the church that shows the church use of it. We will actually own the property. Just for clarification, we wouldn't provide an opinion on title. we would just provide you with a copy of the easement agreement we have with the church.
Okay.
So that the church can use it.
If I delete opinion of title, are you all okay with that?
Sounds right, yeah.
Okay. Done. And that the master site plan permit shall not replace the requirement of pulling individual site plan permits for each building or structure. The applicant must agree to these conditions in writing before commencing site work. Based on the foregoing findings of the fact, the board finds that this does meet the requirements of the Buncombe County zoning ordinance and finds that the applicant is hereby granted a special use permit subject to the conditions referenced above. This is the 11th day of September 2024.
All right, any comments, corrections, or anything on that? Is there a motion on the order?
I make a motion to accept the order.
There's been a motion to approve. Is there a second?
Second?
Hearing a motion and a second, all those in favor, please say aye.
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 Any opposed, nay? Thank you. Passes. Thank you so much.
Okay.
Thank you.
Thank you. Thank you, everyone.
Can we
We'll take
a
a
break?
5-minute break here, and we'll see you in 7 minutes. Yeah. See that? See what I did there?
I just hope the
Everyone's
not
mic on?
Yeah, it's on.
Great.
Okay.
Correct?
Yeah, that's right. We swear you in, yeah.
I certify this public hearing was properly noticed, and all applicable parties were notified of the meeting in accordance with general statutes and county code. I ask that all applicant and staff materials be accepted into the record as evidence.
Without objection, so admitted.
This is the review of ZPH 2024-00021 Murray variance. The applicant is Sandra Murray. Project address is 245 Rocky Mountain Way. Total acreage is .06 acres. Development is served by public water and sewer. Property is zoned R2 with no overlays present. The lot was created in 1996 before the adoption of the current county ordinance and is considered non-conforming due to an acreage of less than the current minimum of 6,000 square feet. The variance is requesting a reduction of the rear setback from 15 feet to 8.
Questions for staff? Questions for staff? Hearing none, thank you so much. We will first ask if there are any parties with standing, or applications for standing, I'm sorry.
No applications for standing that we
Okay.
received.
Any applications for standing in the audience today? Okay. Thank you so much. We'll introduce you, sir, applicant, and we'll. invite
Please
you to
raise
fully
your
sworn
right
in.
hand and state your name.
Tyler Hall.
Do you swear or affirm to tell the truth and nothing but the truth?
I do.
Thank you.
Welcome, sir.
Thank you. I'd like to thank the board for their collective time. As I understand, they are here on a volunteer basis today. And I would also like to thank Griffin Kearns for his, from Planning and Development, for his help over the phone with this case and helping me bring this in front of the board today. My name is Tyler Hall. I'm a project manager and permit specialist with Airvent Exteriors. We're a locally based sunroom company out of Arden. We've been around for 40 years. I'm here on behalf of our client, Sandra Murray. We've always had a good rapport with Buncombe County, and we intend to keep it that way. We're just seeking to amend the setback on the sunroom project for Miss Murray so she can build a sunroom. We'd like to change it from 15 feet to 8. I guess the only other pertinent information would be that we have changed the sunroom design once already to accommodate the side setbacks. And the crux of my argument today is that the property itself doesn't meet the current minimum lot size required for R2 zoning, which makes it very difficult for Mrs. Murray to comply with current dimensional requirements. I believe that's all I have.
Can you speak more to the hardship that this property faces in relation to other properties on this street or in the subdivision? Why it's unique? Well, first of all, the lot line's too close to the back of the house for the porch to be built. That's the issue, right?
Correct.
Okay.
Yes, sir.
And that's true across the neighborhood?
Yes, sir, that is
Perhaps.
true. That
Okay.
is true.
All right. So, sorry, you can continue with that answer if you
It's
want.
fine, it's just, she would be unable to build anything off the rear of her home that projects more than 5 feet. Again, the current, the lot size doesn't meet the current R2 requirements for Buncombe County. The neighborhood having been constructed in 1996 was prior to when the current zoning ordinances were adopted by Buncombe County in 2009. And I just feel that an 8-foot setback for her is consistent for public safety. It still will be 8 foot back from the property line. And hopefully the board will allow Mrs. Murray to make these improvements upon her property.
Can I ask a quick
Yeah, please
question?
do, please do.
What, in the application, what does the term substantial justice mean? Substantial justice is achieved in that Mrs. Murray will be allowed to improve upon her property.
Well, in my opinion, that would just mean that she would be given the opportunity to do so.
Okay, so the next question is why can't she build within her limits instead of, why can't she just build a sunroom within the limits of the space that is already allowed?
It would be virtually pointless in that it would only project from the rear of the home 5 feet. As you can imagine, that's not even room to hardly do anything. If she were to follow the current dimensional requirements, she would only be able to build 5 foot off of the back of her property.
Please, Joel.
Yeah, you mentioned, in your application, I guess the zoning was adopted in 2009. Now, when did your client purchase or begin living on the property?
2016.
Okay, thank you. And the other question for you, since you're representing the client,
Yes, sir.
was she aware of the zoning when she moved in?
My assumption would be no, sir, she did not.
Okay. I mean,
Do we need to call because I believe Ms. Murray is present here, and
Okay.
she can speak and maybe answer some of the questions that you might
Yeah,
have.
that's fine.
Let's do that.
Okay.
Thanks, Ms. Murray.
If you
Thank
wouldn't
you.
mind coming on up, yeah. Thank you.
Absolutely.
Okay, please raise your right hand and state your name.
Sandra Murray.
And do you swear or affirm to tell the truth and nothing but the truth?
I do.
Thank you.
Welcome.
Okay, let me re-ask those questions for the record. Okay, so you moved there in 2016.
Correct.
The zoning was done in 2009,
Okay.
correct?
Mhm.
Okay.
I guess I don't know about the
Yeah,
zoning, but
so
yeah.
is that when you purchased the property in 2016?
2016, yes.
Okay, did you, to purchase it, have to have a survey done?
I just had the survey done because I wanted to do an addition.
So you didn't at the time?
Yeah.
Okay, so getting back to the issue of hardship, okay? So would you say by proposing this addition in the setbacks, you're creating your own hardship?
I don't understand that. I want to add a room to the back of my home, and I back up to a huge field, and there are houses, units on either side of me that have rooms built off the back already. And what I'm proposing is that I do the same on the back of my property. And I won't be up against anyone because it's a huge field out back. I think, did you include the pictures? Okay. Yeah, he included pictures of the view out back and,
I do have those pictures that I can give to you, but they were not included in the application.
Oh,
Just the
okay.
site plan was included in the
Okay.
application.
Yeah, I would like to see those pictures.
May I?
Please.
How many copies of the pictures did you happen to bring by any chance? Okay, if we could get one, we'd appreciate that. Thanks.
Andy, I got a question for staff
Please,
on
please.
this. I'm looking at so this subdivision was recorded pre-zoning, is that correct? Or pre-current? It was, I guess my leading question is, were these setbacks applied to these parcels after they were recorded?
The setbacks as they currently stand are with the current zoning ordinance. The lot was created in 96 and did not have these setbacks on it.
Okay, thank you.
Well, if you could repeat that and hear it, the other properties shown here, they are not required to have the same setbacks as on her property? Or were they built without requesting zoning changes?
Well, they were built all in 1996, I believe is correct, and so they wouldn't have had these setbacks on them, and that's for the entire subdivision. This isn't just to Ms. Murray's lot.
Okay, thank you.
So these setbacks were applied post-construction of this subdivision? And
Yes,
these-
that's
and the- And
correct.
these lots as they stand today are non-conforming with the minimum requirements for this current zoning district, is that correct?
That's right.
Okay, thanks.
So let me ask, is it correct, I'm not quite getting what I should be getting from this picture, but are you saying that there are other houses who basically built sunrooms that went into what is now the setback, but wasn't the setback then?
Correct. I'm not exactly sure when the other sunrooms and screen room projects were performed in the neighborhood, but there are certain properties in the neighborhood that do have sunrooms and screen rooms on the rear that do encroach to the current dimensional requirements.
Okay, so I certainly don't mean to put words in anybody's mouth, but would it be a fair thought to say that one might think it would be unfair that everybody else, or a lot of other people, have a sunroom like the one you want, but you can't get it because you asked too late?
That might be, I was not aware of the zoning issues when I decided that I wanted to add on to my property, and I saw that other properties had, rooms off the back that they had added, and I wasn't aware of the zoning issues, so I went ahead and had the surveys done and everything like that, and plans drawn up, and when they submitted it, they found out about that zoning issue.
Okay, thank you. And just for clarity's sake,
Did I?
along the timeline, at the time you purchased the property,
Uh-huh,
these restrictions were in place, but you were not aware of them
correct,
as
yes.
well?
That's correct,
So
yes.
survey, I think Joel asked, survey had not been done, and so, but those restrictions were there at the time you purchased the property?
Correct, yes.
Is there a HOA form for this community?
Yes, actually, I have some people from our HOA here today.
Well, they're not seeking to testify yet, so we're gonna, afraid.
I know, but are they for or against it?
We don't know, yeah, witnesses, I guess, okay, with parties, so. Yeah, I think I have a question, and it's kind of like it's tumbling around up here, and it's tumbling, and I'm trying to put it together. How do I want to phrase this? This setback rule applies to all properties in this community, and so might a reasonable course or a discussion perhaps in the future be for that HOA to approach the board with a special use permit on a blanket, adjustment?
Since,
I mean,
it looks like to me that most of the lots in the development are non-conforming. So, I mean, you're really dealing with a non-conforming plan unit development that occurred, back in 1996.
Right.
So,
And that- the
and
course of
and
action
I
might
don't
put
know
them-
whether there's homeowners association or rules or whatnot. I think the issue is, would it be better for the homeowners association to come and apply for a new PUD, more or less, to possibly reestablish the lot lines in terms of the, because there's a lot of common area, it looks like, in this development. So that's but that's a fairly complicated fix.
But it would
Otherwise,
help the county in solving and bringing them into conformity, or at least on paper, with a new PUD. perhaps.
Right, well, that would make things a little bit easier and maybe address some of the setback issues and what people can and cannot do. But I don't, because you'd basically then be granting like a major variance, like
Yeah, sort of.
in the PUD thing. So it's fairly complicated.
I don't see how her request is any special than any of her other, like, 15 neighbors.
Yeah, so just to be clear, for the public, we've got, 4 major standards for granting a variance that we have to adhere to. It's very strict, and one of them is that a hardship must apply, or the condition must apply, the hardship must apply to this property only and not neighboring properties in the same way. And so that's kind of, if you've got neighbors that's also affecting negatively, that's sort of
Yeah,
part of it.
I think the hardship has to be, based on that from a strict are we being too strict with our ordinance? And that, indicate how the conditions, is there something wrong with the lot? Is there something, other hardships that the individual didn't create, him or herself or their self? So those would, I think, be the main things that you would be wanting to look at. As her buying the lot, and the fact that she bought a lot that was non-conforming, I don't think that should be counted against her in terms of she should have known better. But,
But
once again,
the same hardship, the same issue applies across the subdivision to other homes across the way from her that may not be able to build a
Sure,
porch
I
because of the
thi-
setback issue.
Sure, I think that anytime, anybody who would be wanting to build an addition in this plan unit, or in this development would be having the same issue. And the problem is that you can't really go by just because other people have done it. They may have built those additions prior to the zoning ordinance coming into effect, or heaven forbid, they may not have actually asked permission and done it. So I mean, that's another issue. You may want to ask the applicant, because it looked like to me on the application that they were using a prefabricated, and I just want to make sure that that's clear, that they're trying to put a prefabricated unit back there. Is that correct?
It's a pre-engineered aluminum sunroom system that we install. So it's not modular or anything of that nature. It's still stick-built, if you will.
Do you have the ability to affect how the size of it?
Yes, we can build to a certain degree, up to a certain footprint.
I guess let me clarify then from that response, Kurt. I'm a little confused now. Can the hardship that she has a narrow setback, just like all her neighbors do, count as a hardship in this case? And therefore, do we have 10 other applicants coming up in the next year to do this?
Yeah, that's
the
what I'm
question.
seeing.
It applies to everybody else too, the hardship. That's my question.
If she gets it, then everybody's going to come to us for the same request.
Right,
And then how is that unique and special hardship?
It's not bad, it
And
doesn't apply.
and I completely agree with you. I guess the question is, I don't think that it would be my role to say whether there is a hardship or not. I think that would be up to you. You can ask me the question whether you think it's defensible. I can answer that, but I think that the board needs to make, based on the findings of fact, whether there is a hardship or not. I think we're in a very difficult situation just because of the non-conforming lot and the fact that the entire, basically, development was done before zoning. But, if my suggestion would be is that they may need to look at that more on a development or the whole neighborhood and not just one property on an individual basis.
Yeah.
Yeah.
Yeah, I like Kurt's idea, because I think this is kind of unique. He has an issue, but here's a whole development.
Right.
The other question, going back to hardship, because I think for me it's confusing. You buy a piece of property and have no idea where your boundary lies. Okay? And then something like this comes up. The question for me is, then are you creating your own hardship?
She did have, she did.
due diligence to find out even where your boundary line.
Well, I didn't approach any builder or anything like that. I had the survey done before I contacted, I'm like, oh, I've got 20 feet out, I can go out. You know, it's my property, I can build out to that. Because I'm not up against another building, I don't know, what, 40 yards away from my back neighbor? I mean,
Right, but unfortunately, your lot is non-conforming, and with that, you can't just automatically expand your non-conformity.
well, that's my ignorance.
No,
I
that's not, that's not,
apologize
that's
for
not,
that. Yeah.
I'm not your thing. You
Yeah.
know, you all may want to talk about the process that you went through in terms of, you know, how'd you determine the size of your, you know, why you've come with 8, you know, the request, or did you try other options to try to fit something in there?
Well, like I said, if I conformed, it would be, the room would be 5 feet wide. I can still build the length across the back of my place, but it would only be 5 feet wide, and I wanted a 12 by 16 room.
Well, can you
yeah.
increase the length?
Oh, I already have. I've got it going from one end to the other window. And then I was gonna put a little patio off to the side that goes to my back garage door.
One question I have, can you tell me how many homes approximately are in your development?
Oh, gosh. 70.
70, okay, thank you.
So I guess this is a sticky one here because we, and I'm saying we as a member of a county board at this point, but the zoning was applied retroactively to a non-conforming lot. That lot is roughly 65% smaller, or 65% the size of the minimum in this current zoning. So you go back to that test of, you know, the variances, and does the unnecessary hardship result from strict application of the ordinance? I mean, I'm playing both sides of this. It's not their fault that they have non-conforming lots. That's an issue that came because the county decided 2006 to adopt a zoning ordinance, but you can't change people's properties at that point. The thought, and I'm, you know, that minimum lot size for R2 was developed with, you know, reasonable uses of their property, with application of those front, side, and rear setbacks for that minute. So, you know, 4,000 square foot lot, there's a lot of different, there's a lot more you can do with it than you can with a 2,600 square foot lot.
Mr. Chair, can I ask if we're still asking questions of the,
We're still in open hearing for the applicant.
okay.
Ask a question to the applicant if you'd like to. We'll deliberate later on. Yes. Oh, yeah.
Yeah,
We're doing back and forth with the applicant here, so let's do that. I'm sorry.
yeah, okay.
I'm kind of curious about the HOA witnesses.
Yeah, sure. Let's, is anything else from y'all at this point? We'll have an opportunity to do a closing statement.
I
before.
can't think of anything else. I mean,
We're mulling through. You see us thinking?
How about this? Can I ask a quick question? What happens if you can't build it?
Well, I've paid for the supplies and everything, and I bought all the furniture and the flooring, and it's all stacked up in my living room, but other than that, I mean, I'm just stuck.
I mean, she'll most certainly
I'm-
get any money she gave to us back.
Let me ask this, though. On the,
But
on this.
I also want to say, I'm perfectly willing to pay the higher taxes for the larger unit.
There you
Wouldn't
go.
that help?
There you go. On the survey that you, engaged in and purchased before the purchase of this property, did they identify the 15-foot setback?
No, he just gave me the parameters of my lot.
At this point, we can open public comment and ask for any witnesses who are here to speak on this project. Any show of hands, with anybody wishing to say a word or two on this project? Yeah, sure. Please, ma'am. We'll start by swearing you in and have you speak into the mic.
Please raise your right hand and state your name.
Carolyn Fauché,
Do you swear or affirm to tell the truth and nothing but the truth?
I do.
Thank you.
Welcome, Ms. Fauché.
Thank you. I'm a neighbor. I'm a board member. My husband, who just left, he'll be back in a minute, is the ARC, chairman of the ARC committee, which is the Architectural Review Committee. He took that over in 2018 when I went on the board. He does not have a vote. He does not have a background other than personal construction and homeowner for many, many years. Sandra came in with her request and her plans. And we looked at them. My husband looked at them. His committee looked at them and approved them based on her following Buncombe County building codes
As a condition.
as a condition.
Yeah.
Yeah. It went before the board. The board approved it based on my husband's recommendation. Sandra has been since June?
2016.
When?
2016. is
Yeah,
we
that's
did-
when you bought, but when did we start this process?
Oh, gosh.
In the
I s-
spring.
I started in February.
In the spring.
Right, yeah.
So in the spring of 2024, we've been dealing with this. There are many, many properties in our development that have buildings off the back. Screen rooms, three-season rooms. I don't know what the process was before we moved in. We moved in 2017. This is the first building that we've had since we moved in, other than a screen room directly behind our unit, which was done prior to us being involved in the HOA or the ARC. I understand, and I heard what you said about the whole property getting a variance because of the way it was built. I think that that's probably a good idea, and I'll probably take it to the board at our next meeting, which is Thursday, tomorrow. I don't know what to tell you about Sandra's, because this is way beyond what we expected. We thought it would be a simple matter to get a variance, but we didn't know the rules. So here we are.
Yeah.
Question for you?
Craig.
And again, it's just your personal opinion, I assume, but knowing the neighborhood, knowing the community, are there others like Sandra that would potentially want to do what she's doing?
Yes.
And the second question is, you said you would take it to the board. Do you believe that you would receive support from the board and support from the community to come forward as a collective group to make this request? Just a presumption, again.
Yes.
Okay.
When that would happen, I don't know. We are in the middle of a project with Arden Woods, which was the main builder of our units way back when in 1996. They split off ours in 2003, because they didn't want mortgages. So we own our stuff. The other ones are, there's a Alzheimer's care unit, and there's apartments at the top of the hill for retirees, a lot of people up there on walkers. So we are separate. So we're going through this thing because you don't need to know that. I don't know when this would happen because we're in the middle of some other negotiations at this point and still trying to figure out how we're going to handle that.
Okay, understand. Thank you.
You're welcome.
Joel? Yeah.
Yeah, I was gonna ask the same question as Greg, if others are gonna come. I have no idea how many. I just assume it keep us employed for a long time, okay?
Job security.
You know, and I like the idea of fixing the whole thing.
Yeah, I do too.
And if you do that, just personally, I would consult with some legal counsel
Yeah,
to
that's,
help you navigate the process. I mean, that's why I would not vote to grant this, since we know this is in some ways, the tip of the iceberg, okay? So, you know, personally, I feel make everything right.
I hear what you're saying. I feel sorry for Sandy because she happens to be the one that got caught in this mess. It's a mess.
Mm.
It's a good thing. She's the groundbreaker. She's
Yeah.
in the pack.
I don't want to be a groundbreaker.
Yes.
I think staff, we have something that we might be able to help with this.
Can't hear you.
Okay.
I'm going to swear in Jason Payne because he has
true.
a staff remark that he would like to add to this. So please raise your right hand and state your name.
Jason Payne.
Do you swear or affirm to tell the truth and nothing but the truth?
I do.
Thank you.
I just wanted to put forth that, you know, what we have here is a plan unit development. This is a townhome development that was put in place prior to zoning. If this were to be constructed today, it would be coming before this board as a plan unit development. And in that plan unit development process, they could ask for deviations of certain things. One of those things would be the interior setbacks. They could be set at 0 feet. They could be requesting 0-foot lot lines along all sides. If hypothetically that plan would have come to the board, or if the HOA decided to submit a plan unit development and make this non-conforming PUD a conforming PUD, then, you know, they can request these 0-foot setbacks along all of these lots, and it would eliminate this issue altogether. So I'm just kind of putting that out there that, you know, this is just one individual lot. So they're bound by these townhome lots, but they did not have the opportunity to request those deviations that might alleviate this kind of situation. So I just kind of wanted to just put that out there to ruminate on.
And I just want to add that I think also that also kind of goes to the hardship issue too, is that, you know, the fact that does go to that. But I think that, you know, you all need to kind of consider that too. What's the best solution for your subdivision? So.
And of course, we can't predict any future deliberation or decision, but that sounds like what the board and staff think might be the best course here for that application to come forward for the whole community. And on the hardship question, just to be clear about what I was ruminating on earlier, was one of the 4 conditions that we're required to look at for a hardship. The reason some of us are uncomfortable moving forward today on just your lot is the requirement that the hardship should result from conditions that are peculiar to the property, such as location, size, or topography, hardships resulting from personal circumstances, as well as hardships resulting from conditions that are common to the neighborhood or the general public may not be the basis for granting a variance. So that's the core of why we are having trouble today, you know, because it applies to the whole neighborhood. So that's my, am I incorrect there?
No,
Okay.
no. I also do want to point out too, is that that when you look at the map of the entire subdivision, not all the houses were laid out in the same manner. It looks like to me that some of the houses have a much larger backyard as opposed to the applicant's backyard, which is actually not as big. So you kind of have that unfairness where, you know, if the house you bought, that lot, you could possibly do something where you can't. So that's something else that you all may want to consider.
Okay.
Yeah, I would recommend, this is a sticky issue, and I'm empathetic, okay? But I would recommend, you said in a couple days you have a HOA meeting, and I know you said you have ongoing project, but since this goes beyond the issue here, I recommend you withdraw this, talk about it as a HOA. And you may say, well, we don't wanna fix everything, and then possibly you could bring them back in front of us, okay? Because the issue comes down to, I brought up, another member brought it up, okay, with this happening now, how many more requests for a zoning variance are we gonna get from this development? And you probably can't answer that.
I can't, I know that some of the units, there's no way that they could build on the back based on how they're placed on property.
Well, that's what I'm concerned with,
Yeah,
because if we approve this one, and someone decides, hey, she got approved,
oh,
yeah, I wanna do it, so are we setting a bad precedent? Because in some ways, we're not looking at an individual case here.
yeah, this board moves for everyone. So any decision that's made by the board is applied across the board to all units.
Your board,
My board.
your board, okay.
My,
Yeah.
I'm sorry.
Yeah.
My board.
Okay.
Didn't mean to be confusing. I'm sorry, Sandy.
I think what we're trying to do is that the rule of law right now is may put the board in a difficult position.
My hardship.
Well, right, what the problem is that if your variance gets denied, you can't do anything for another year.
So we want to pause it. We don't want to.
So what we are trying to do is feasibly help you get to do what you want to do without us in a legal manner.
Right.
And
I
also
think
to
really-
extend that same privilege to the other homeowners there, yeah.
And basically not to have, like, every time somebody in your subdivision wants to do something, having them have to go through this process. The only thing is that for the applicant, it may take a little bit of time. And that's, and from what it sounds like, that's really gonna be what you need to think about. But, I just think, though, that if you go through the HOA or at least let the HOA think about that, and if they decide not to, then you could possibly come back. And then you would have that the HOA decided not to do that, and that would be a factor in the board's decision.
So, so taking those comments, tacking onto that, a denial of a variance does have a one-year period where you have to wait and come back. So I recommend that we just table this one and allow it, and then the applicant can go ahead and withdraw at a later date, if they need to.
If it's okay with the applicant, and I'm not trying to, so this is your
Oh,
choice.
no.
So
I mean,
I'm
if there's
just,
a, if
mean,
there's
you all
a
don't
way
have,
to move forward.
you all don't
because-
have a lawyer, and I'm not trying to, but I would think
No,
that
I realize you're trying to help
we may
me.
want to continue this to a date certain, like not October, but maybe continue
months
it
out.
to November.
Okay.
I don't know if that would give you 2 months to try to,
Yeah, you might want to make it a little longer than that. I mean, some of us have experiences with HOA, and they're not the fastest things in the world.
I'm fine, I just want
Actually,
them to know.
Actually, we're quite quick. Yeah, we are. The problem is going to get a lawyer that will represent us and get that work done in an efficient manner. That's the problem.
You might not need a lawyer, you may just need a design professional
mhm.
and an engineer. You may need to like get that. I don't know if, you could get a lawyer, that would be help, but I think your more thing is, and I know staff will work with you to help get your application.
We're looking
And
at
to-
a lot of dollars.
Who would they need to get?
Somebody like a Clay Mooney, a landscape architect, maybe, somebody
They
that's.
could appear with you on your behalf, either one, yeah, so.
I mean, really what you're doing is you're just gonna take a map of your subdivision and basically ask that the set, that to file the application, pay the fee, and then get your setbacks adjusted.
Okay. And I get,
No, that's.
As soon as we have,
Yeah, I mean, there are other standards. I mean, there would be other standards for the, I mean, that's a point, that there are other standards for the plan unit development, and we'll give you the statute and you all can look at it. I don't know about your road size, but I mean, but some of those standards can be deviated.
I've got a question for you, Kurt. 'Cause we've heard in some instances, if this was built, then they did zoning, kind of, why weren't they grandfathered in? Or is this, I guess maybe this is before they put these additions on?
Yeah, that's a good point, Joel.
Well, I think it comes down to what is the nonconformity. And in this case, the lots, the use is not a nonconforming use, the residential use, but the lot size is. And since the house is already there, it's not like we're making them adjust their houses to come in with the current things, but the fact that you want to expand your house, you would need to then come into compliance with the existing ordinances if you were going to change how you're using the property. To an extent that you're adding something different, you're expanding your non-conforming lots in your house.
okay, so I think we have a direction to face at this point and to point in, at least.
yeah,
So.
I have a question about coming back as an organization for all the homeowners to request this.
Right.
So we would be requesting, it's just clarification. So we would be requesting, this board, to do a standard variation for everybody in there.
What you would be
Let's,
doing
let-
is submitting a PUD, a planned unit development application.
Okay. And then,
And that-
will that have to now come up to your current situation, the current laws?
To the extent that that may be an issue for certain. I'm trying to think of the standards for lot sizes, roads. I mean, we're looking at your subdivision. It doesn't look like there's.
The roads are private, so
Okay.
we take care of the roads. The water system is billed through Arden Woods. That's going to cease.
the subdivision's good. Right, so
What-
all it is just the PUD.
Can I ask why it couldn't be a special use permit retroactively? Can I ask why it couldn't be a special use permit application retroactively?
I think that's the
Oh,
discussion.
okay.
Yeah, I think that's what we're trying to
A PUD
do
would be
is,
the type, okay.
is have the subdivision submit or not the I'm using subdivision incorrectly.
HOA?
Having the plan unit development, because right now it's a non-conforming plan unit development, right? So then they would basically be submitting a plan unit development application to adjust some of the standards.
And they could deviate from from our standards in that
You
application.
could grant a
with-
variance in the application, like building heights and setbacks and things like that.
So if you run into things, consult with staff and your
Thank you.
professional, and then
Yeah.
figure out how to present
Yeah,
it.
that would be very, very helpful if we
Yeah.
could do step-by-step so that I could present it to the HOA board so they know what we're talking about. We just actually came to back up.
Supportive.
To support Sandy today.
For moral support.
Yeah, I didn't do such a great job, Sandy.
Did a great job.
No, not
Did a
at
great
all.
job.
I think you
Did a great
added
job.
lot.
Yeah. Thank you for being
All right,
here. yeah.
thank you.
And you consult with staff and get
I
your
will,
professionals
if
lined
I
up
could
as soon as
get
you
a
can.
card, and then we can, thank you so
And
much.
we'll do a 2-month period then, sounds like. Yeah. Yeah.
Are you all okay with continuing this?
Yeah, yeah. I think that's the best course.
Yeah.
Okay, well,
Okay.
thank you very much.
Wonderful.
Yes, thank you guys for your help with this.
Any closing statement or anything else?
I just, again, want to thank the planning committee. I'd like to thank you guys for your time. You know, this is a unique situation, as we can all see with the lot sizes not even, you know, meeting the current R2 standards. I do see y'all's perspective about not wanting to have 10 variances coming up, you know, in the future.
Yeah.
So I appreciate you guys helping us through this process, all of you.
Hey, thank you so much. We
Yes, sir.
appreciate it.
See, I was supposed to be the inspiration for the neighborhood.
There you go. You're the,
If it helps any, ma'am, until I was about 30 years old, all I had was outdoor furniture in my living room. So you're doing well.
I don't have
Yes.
a living room.
All
I've
right.
got everything stacked in the living.
sorry, yeah, sorry, guys. Kurt?
We would need a motion to continue this
Yes.
to a date certain.
I make
Yep.
a motion to continue it to a date certain. I think we said 2 months next November.
One
There's been a-
question that I have before,
Let's get the motion on the floor, then we'll do your question. There's been a motion on, to table, so to continue it to the November meeting, regular meeting of the board. Is there a second? I hear a second here. All those in favor, please. Oh, sorry, discussion,
okay,
please.
I'm not sure, you have to forgive me for this. I'm not exactly sure I understand what it is we're continuing. Are we continuing, it's not her request for a
Yes.
variance on her property?
Yes.
It is.
Well, sure, I understand that, but we've been talking about PUDs and stuff like that. What does that have to do?
I think what we're trying to do is see whether the homeowners association will take any action to try to remedy this situation before we rule on her individual.
Oh, so we're doing
variance.
this in case they don't do
Yes.
anything?
Right.
Exactly.
Okay, gotcha.
Exactly.
We just need kind of a parking spot for her for a while. and
Gotcha.
This seems
Thank
like
you.
a good spot.
Yeah, we may see a different application come forward from the whole HOA.
Gotcha.
Okay,
Is that,
yeah.
Yep.
And we said something earlier that was erroneous, that was, I think, false. Let's correct that. The HOA, if they come forward with an application, they do need an attorney. Yes?
you do not have to have an attorney.
The HOA doesn't? It's representing the
Well, if-
neighbors?
Engineers to present to us and things like that. Now, if it's contested, or there might be, you know, I can't answer that, whether they have to. I would not, we've allowed engineers to present on behalf
But
of.
the HOA can come and represent themselves by their president, due to a vote of the majority of the HOA members.
I would recommend that they get a design professional
Okay.
Yeah,
to present
A
that.
landscape architect. probably-
Yeah,
probably-
not necessarily just have like Joe, one of the members of the board. I would think that they would want to, you
Probably
know.
the cheapest way to go.
Yeah,
landscape
usually,
architect.
we allow design professionals sort of to represent their client, but we don't, and not in an attorney kind of capacity.
Yes.
And I mean, we obviously don't know what the future holds, but being that this is an internal community, I can't imagine there's going to be much resistance. I mean, if the HOA comes to speak as a group, I'm assuming this isn't going to affect anybody else. Probably.
No, I agree.
Okay, so any further discussion on that motion? Hearing none. All those in favor, please say aye.
Aye.
Any opposed, nay? That motion passes. Thank you so much.
Well, thank you very much, and thank you
Do what we
for-
can to work this out.
Thank you
Thanks,
for
guys.
helping me in the
Yeah,
process.
there we go. Now we have a pathway, yeah. Thank you very much. We'll move to, to case 2024-00401 River Knoll, Phase 3 subdivision variance. We've got Shannon Capizelli to present, if she's. Did River Knoll, I'm sorry, did Brandon Freeman say he wanted? He wanted to continue, okay.
Yes.
Which one was not continued?
Was there a motion to
Clayton
continue?
Crossing Special Use Permit
Clayton Crossing.
Amendment, that's where we are.
All right. Let's move down to 2024-00028 Clayton Crossing, Special Use Permit Amendment. Mr. Jason Payne is with us. Clayton Crossing.
sir. One moment while I pull up the site plan. All right, my name is Jason Payne, and I certify that this public hearing was properly noticed and all applicable parties were notified of the meeting in accordance with general statutes and county code. I ask that all applicant and staff materials be accepted into the record as evidence.
Hearing no objection, so accepted.
Thank you. This is the review of ZPH 2024-00028 Clayton Crossing Special Use Permit Amendment. The applicant is Chad Carson of DRB Group North Carolina LLC. LLC owns the parcel. The project is located at 7 Moonhaven Way. The total acreage is 7.36. The development will be served by public water and sewer. This property is zoned R2. Just want to make sure everyone's very clear here. So this is an amendment. This special use permit was heard by this board and approved the original design layout on August 10th, 2022. This amendment, and the applicant can correct me if I am wrong in this. The original developer, the original applicant, had plans on renting these units. There was not plans for subdividing this into townhome units. It was just going to be rental properties, just kind of designed as townhomes. However, that has been sold now. The site has already been worked. The site work's been done. Roads are completed. But the new developer and owner would like to subdivide for these to be fee simple townhomes. There is no change to the approved plans that the board has already approved back in 2022. This is simply to subdivide into the townhome lots with the deviations requested, as we were kind of discussing in that last case, those standards done. So just wanted to be sure to know there is no changes to what the approved plan was other than the lot lines. That's it. The deviations being requested would be the minimum lot size. Each townhome lot is about 800 to 900 square feet. As you were just talking about, the minimum lot size in R2, serviced by sewer, is 6,000 square feet, and they're requesting 0-foot interior setbacks to accommodate the townhome style lots. If approved by the board, staff recommends the following conditions of approval, which I will summarize. A major subdivision plat must be submitted, approved, and recorded prior to any approval and any further building permits on this site. The project must be constructed as depicted in the site plan. The project is subject to all agreed-upon conditions as stated in the orders that have already been approved under ZPH 2022-00010, and the applicant must agree in writing to these conditions prior to continuation of site work. That's all I have.
Any board inquiries?
I've got one question on the address.
Yes.
The application has it as 642 Long Shoals Road in Arden? But that
It
wasn't
does.
what you said, right?
So prior to the addressing of this project, that parcel was originally 642 Long Shoals. The original application was under that address. Since site work and even the building permits have begun to come in, addressing was a part of that. As part of that, the parcel was readdressed to 7 Moonhaven Way. 642 Long Shoals was the previous address of that. So I think there was just some confusion there on the application.
Any other questions? All right, we're ready to go.
Thank you.
Thank you. We'll have the applicant approach at this time and also ask staff if they've received any applications from the public for standing.
No applications for standing.
Okay, thank you. Anyone in the audience today wishing to assert standing in this matter as a party to the? No? Yeah.
Okay.
Yeah, that's cool. Yeah, there's a public comment later on. Yeah.
I
Welcome,
will
y'all.
swear each of you in, starting with the gentleman sitting closer to me. Please raise your right hand and state your name. Do you swear or affirm to tell the truth and nothing but the truth? All right. Please raise your right hand and state your name. Do you swear or affirm to tell the truth and nothing but the truth? Thank you.
Welcome, gentlemen.
Yeah, could you speak very close to the microphone?
A little better. There it is.
I'm sorry, guys. Chad Carson with DRB Group of North Carolina. So essentially, our request is to amend the previously approved SUP PUD to give us the opportunity to subdivide the lots. Relatively simple, nothing's changed in the layout. Nothing's changed in the number of units. As far as the density, open space still remains the same. Roads are still the same, ingress, egress. We just wanted to give our residents the opportunity to have the fee simple lots. And as staff advised, this is, we did not have the previous application. So once we purchased the project, we just felt like this was a better route for the future residents.
Questions, comments?
Is there any issue with like water meters or electric meters or anything like that?
No, the community is master metered, and it will remain that way. It'll have to because that infrastructure is already installed. So the HOA will pay the water bill and the sewer bill.
All right. Pretty straightforward. Other questions, comments? Don't say that. Gets to death. Okay. Any other professionals you want to call up? Any other expert witnesses or anything else?
No, sir, not at this time.
Wonderful. Anyone here to speak on this matter? Public comment? No? Seeing no hands, we'll close that portion. Any more board questions? Okay. Any closing statement or anything else you want to say?
No, I think it's hopefully pretty straightforward. Again, our goal was to keep everything exactly the same as the previous applicant did, just with the opportunity to subdivide the lots.
Okay, perfect. We'll close the public hearing and open for board discussion, deliberation.
I think it's a fine thing to do, and if nobody else disagrees, I'd love to make a motion.
There you go. Okay. Yeah. We'll have discussion on the motion too. Yeah.
I've done this same thing in the past, just due to market conditions, et cetera. It's fine. It's
Yeah, I
a great
think it gives
idea.
them more options.
I completely understand why.
And this one's Clayton.
Yeah, Clayton.
Okay. Mr. Chair, based on the evidence presented in this board, including the following exhibits, the petitioner's application, the submitted development plan, GIS maps, the staff report, testimony presented at the hearing, I move that this board adopt the following findings of fact: that the matter was properly advertised, is within the board's jurisdiction, and is ripe for consideration, that this application, together with the conditions proposed by staff and/or this board and agreed to by the applicant, if any, does meet the requirements for granting a special use permit contained in Buncombe County Code of Ordinances.
There's been a motion on findings of fact. Is there a second?
Second.
Hearing a motion and a second, all those in favor, please say aye. Aye. Any opposed, nay? That passes. Thank you.
All
Second
right.
motion.
I'd like to make a motion based on the foregoing findings of fact and for the reasons set forth therein. I move that the requested special use permit be approved and that the order approving the permit be adopted and executed as presented and as modified in the meeting.
There's been a motion. Is there a second? Hearing a motion and a second, any more discussion? It's pretty straightforward.
Mhm.
Yeah. All right, sounds good. All those in favor, please say aye. Aye. Any opposed, nay? That motion passes. Thank you so much. And we'll ask that staff present an order to us for approval. We are.
Mr. Chair, members of the board, I have the following order. This is for a special use permit regarding using County Code of Ordinance Section 78-641, 78-677, 78-678 for a proposed subdivision with 70 lots at 7 Moon Haven Way. That the sections used, that the land is, it will be under single ownership, that the density is consistent with the zoning, the land uses are compatible with this, compatible with the character, with the intent of the zoning district. The proposed land use meets the minimum requirements for land development in that the minimum size and interior setbacks do preserve the spirit and intent of this section. The proposed heights do comply with the spirit intent of the zoning ordinance. The board finds the minimum distance between buildings will be adequate, that the development does provide for reasonable visual and acoustical privacy, that the structures of the perimeters will be set back from the property line. The board finds that the proposed parking does comply with the spirit intent of this section, and that the community-owned facilities are in accordance with North Carolina general statutes. The board finds that the building envelopes are shown to be submitted on the plans for the proposed footprint, and that the proposed use will not adversely affect the health and safety of persons in the neighborhood. The proposed use will not be detrimental to the public welfare, injurious to the public property. The proposed use will not cause or have adverse effects on surrounding properties due to noise, odor, glare effects. Satisfactory ingress and egress has been provided. Off-street parking has been arranged for. Adequate utilities have been arranged for. Provisions for buffering, if applicable, have been arranged for. Any signs, if applicable, are in harmony with the properties in the district. Playgrounds, open spaces have been arranged for. The building structures are acceptable. Hours of operation are acceptable. The following conditions are that a major subdivision plat must be submitted, approved, and recorded, and that the project must be constructed as depicted in the site plan, and this project is subject to all the conditions stated in the orders for ZPH 2022-10. The applicant must agree to all these terms. Conclusions of law that this does meet the requirements for a special use permit, and that the board does grant the special use permit. This, the 11th day of September 2024.
Thank you. Any questions or comments or motion on the order?
I'm making
There's a motion over here. Is there a second?
Second.
Second, okay. All those in favor, please say aye.
Aye.
Aye. Any opposed, nay? That passes. Thanks so much. Moving to case ZPH 2024-00014, the Kuhn variance, continued from August 14th, 2024. And we're going to push it to later in the meeting. I think the the applicant's here, right? I think they are, yeah. And this, who wants to give a blurb from staff? Thana? Yeah, Thana will come up and do a, you'll be here, sir, and if Thana can come up there and do a blurb before you start.
I certify this public hearing was properly noticed and all applicable parties were notified of the meeting in accordance with general statutes and county code. Ask that all applicant and staff materials be accepted into the record as evidence.
See no objection, so approved.
The review of ZPH 2024-00014. Applicant is Devin Hutton of Ecoculture PLLC. Property is 5 Wiley Drive in Asheville. Total acreage of the property is .72 acres, served by septic and public water. Zoned R1 with no overlays present. Applied for the variance to the zoning ordinance of Buncombe County, section 78-642, to reduce the front yard / roads right-of-way setback from 20 feet to 10 for a pre-existing storage building which was constructed without permits. Applicant has also requested reduced setbacks for a future home site due to the width of the parcel.
Okay, any comments, questions for staff? Hearing none, thank you very much. Mr. Kuhn, how are you today? Great, we'll swear you in.
Please raise your right hand and state your name. Do you swear or affirm to tell the truth and nothing but the truth? Thank you.
Thank you, welcome back. You may proceed.
I just was here to ask for a continuance. I'm here to ask for another continuance.
Okay. What's been the progress in the past month, maybe, since?
I had talked to Savannah just last week, confirmed some, I guess, for lack of a better way of saying it, verbiage. Guess it helps if it's on. And when she had replied back to me, there's now some new information that seems to make this easier. I have no idea, I did not ask her why this information was, I don't know if she's done some due diligence on her own, but now that I've reported that information back to the attorney, it's a slightly different path than when I asked for the continuance last time. It should be more streamlined. I can't necessarily speak to what exactly that is, but in this case, it's going to make it much easier for me to probably answer and make what we're trying to do easier to digest with my neighbors. This new option won't affect them as directly or raise whatever their potential questions might be, which was what the attorney's question was. So, like I said, Savannah's response dictated this new path, and we just need slightly more time now to just kind of reshuffle what we're trying to do.
Okay, so you've engaged an attorney on this?
Yeah,
Are they
since
planning
you
to-
told me the first time.
Have you asked him to appear for you next month?
He's willing to do so when we're at that point, yes.
Okay.
But he's told me it's not within my best interest to do that right now.
Right.
Yeah.
Okay. Board comments, questions?
Yeah, I know last time he appeared, some of the things we suggested about getting legal counsel and open up communications with his neighbors. Seems to have done that. These things don't happen overnight, so I would agree to a continuance.
Yeah, if we agree to a continuance, can we say that this is going to be the last one?
We can just say, we'll do a date certain, and then you can decide, the board next month will decide what they want to do. No, we're not there yet. Yeah, any questions for him?
That's a very good question. I'm just, at this point, going through the motions myself. I've been a liaison at best. The attorney's very busy, took me 3 weeks to vet that person in particular. I'm confident that we're gonna be able to get this through. The hope is that I won't have to come in front of the board at all, but that is yet to be determined. So if we can do this, I might not even have to come. There was an option to withdraw this today. If the board said, hey, we're tired of doing this, I was gonna then ask that. So I don't know how to answer that question. I've asked as many questions as I can, and I've been patient to get the responses back from the attorney, but I'm not the only person he's serving. And I guess this is why they say patience is a virtue.
I guess the board's general feeling is let's continue to next month, and if you'll relay to the owner that that's when we want to hear the case, and if we don't hear
Now,
the
if you
case
were-
that next month, then we'll act on that day.
Yeah, now if you're to say here to me that we're not going to continue this again, or next month is the last time we hope to see you, which is fine, then I can just tell that to the attorney. But at this point, I'm just reciting information that I'm told.
Yeah, that's right. And if
Okay.
you'll just tell the owner, the board discussed today, which is that they want to hear the case next month.
Yeah,
And
sure.
if they don't hear the case next month, there's a risk that the case won't continue past next month.
Understood.
But there's this board can't bind next month's board, so we
Yeah,
can't make
fair.
a decision now.
Cool.
So, but thank you for being here today, give us an update. We
course.
appreciate it. And next month works, there's okay. October 9th, I think it is. We will at this point ask for any witnesses in the audience. I don't think there's anybody's behind that TV, so I can't tell. Going once, going twice, all set, okay. We'll close the public hearing and open for board deliberation and discussion and a motion.
I move to approve to continue to next month.
There's a motion to continue to the October meeting. Is there a second on that motion? There is a second. All those in favor, please say aye. 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 Any opposed? Okay, that motion passes. Thanks so much, Mr. Tutton. We appreciate it. Moving now to KCPH 2024-00017, Asheville Forest Bath Special Use Permit. We're continuing this one, hearing this today, continued from August 14th. So we'll ask that Dana help us out with a brief summary, and then we'll call the applicant.
Okay, so this is the review of ZPH 2024-00017 Asheville Forest Baths. Applicant and owner is Bella and Spencer Fishbane. Project is located on properties 54 Indian Mound Trail, 11 Hunter Road, and 13 Hunter Road, and the total acreage of them combined is .9 acres. Properties are zoned open use with no overlays. The special use permit is for a conversion of one single-family home at 54 Indian Mound Trail into a short-term rental to create a vacation rental complex spanning the 11 and 13 Hunter Roads and the subject property.
Thank you very much. Any questions from the board? Okay, thank you. We'll call the applicant, and we'll do a swearing in briefly, and then we'll speak into the microphone as you.
That had happened at the prior hearing. Yeah.
Okay, yeah. And while you're approaching, sir, is there anybody else in the audience to assert standing?
I don't see another
see it.
soul in this room.
Okay,
So-
I'm relying on you. I can't see it, so thank you. Hey, welcome, sir.
Hello,
Hi. Please raise your right hand and state your name.
my name is Spencer Wright.
Do you swear or affirm to tell the truth and nothing but the truth?
I do.
Thank you.
Thanks for being here today.
Okay, so we've been running Airbnbs. We have 2 units that we developed when we purchased the property. They were originally permitted as sheds. We went through the county and planning and zoning and got those brought up to single family. We've been running those 2 units. That's 11 and 13 Hunter. Those are accessed via 54 Indian Mound Trail. So we have 2,000 square feet. It's 100 linear feet and it's 20 feet deep of parking in the front of that section, and then we have trails that lead back to those cottages. So our guests park in front of the main house, and then they walk back. We currently live at the main house. And yeah, we'd like to bring the main house, we'd like to have a permit to run the main house as a rental. We don't plan on doing that right away. We just want to go ahead and get the permit in shape so that if we were to buy another property in Fairview, we could then roll that into a short-term rental. I do apologize, by the way, that we weren't here on the last meeting. There's some confusion there on our end. And there were some people who spoke against the project, and I wanted to address a couple of their concerns, which I think mostly came down to the road and impact. I have to say I really appreciated hearing from some of the people. One of the people he has texted me periodically, but it's difficult to get good information on how to fix the problem. That was the most information I had heard on, to date, of what really was causing the problem for him, and we've already gone on to address many of those things, I think. One of them specifically was the service entrance. We had it blocked to the road so that we did not have people coming onto that part of the property. We've now moved that back so that there is now another turnaround spot on Hunter Road, which was creating some of the problem. That people would come down Hunter Road, they would have nowhere else to turn around, and so they would turn around in his driveway. So now there is another turnaround on Hunter Road. And we've also put signs in there directing Airbnb guests to use that turnaround to turn around and get back to the property. It's worth saying that none of our guests have any addresses towards Hunter Road, and none of them have any reason to ever be down there. So it's not as though we're directing people, but people do get confused, so that helps with that. There were some concerns around road maintenance, so I pulled receipts. So far in the last 10 months, we've spent $1,750 on road maintenance and 4 different dumps of gravel, which to my belief is all the road maintenance that has been done on Indian Mound Trail during that time period. During the last dump, we did take additional gravel down Hunter Road, which is this neighbor's road. He was frustrated about a part of his road. I do not think that the damage was caused by our guests at all. It's just a runoff because it has, it doesn't have, I can't remember what you call it, little drain lines next to the road. It doesn't have any of those, and so it floods. We put a whole bunch of ballast onto the road for him because honestly, we don't want the rentals to cause any problems for anybody else. I would much rather people be thinking that it's a great thing to have Airbnbs on the property because they're maintaining the road, which is true. So at this point, we don't need to do any construction. We don't need to do any additions of any kind. We're really just looking for the special use permit so that we have the option to run the main home as an additional rental if we wanted to. I think it's also worth saying we also own an adjacent parcel. So though the rentals are on 0.9 acres, we own 1.5. It's just one of the parcels is undeveloped. And I think that's about it.
Okay, questions from the board? Joel?
That question, the concerns you just brought up, this was brought up last time. The people who expressed those concerns, so that they're fine now with everything? And how do we know that?
I would not speak for them, certainly not. I have not been able to speak yet with the, well, her first name is Molly, who lives at the bottom of the hill. I did find it a little ironic because she also runs an Airbnb, but it's not really relevant technically. But yes, she lives down at the bottom of the hill. I haven't yet gotten a chance to speak with her. I have some other signs that I'd like to put up and things like that, but I do not have it in writing or anything like that they would be okay with that. No.
So, just refresh my memory.
Yeah.
Okay, so these concerns were brought up by neighbors.
Were those neighbors aware of this meeting?
I do not know.
Well, this was, I think originally, this was originally scheduled in August. And I believe that the the neighbors were here present and presented testimony.
Yeah, we heard that.
And then you all continued it to a date certain, which was today. So, so we would not have gone out and reposted or anything because the hearing was continued to a date certain.
And they heard that in the hearing when they were here.
I would assume so.
So you talked to the gentleman above you on Hunter Road that had the driveway turnaround issue.
Yes.
Did you talk to anybody at the HOA below you at
We-
all about the road condition in general?
We do not have an HOA.
You're not subject to one, right?
Right.
And is there one down the road that shares Indian Mound?
No.
We were told last
I
month that
think
there
it
was.
that woman on Blue Ridge Development or Blue Development Road or something like that who's doing it herself on her own volition. I don't think there was an
Yeah.
HOA.
It's all private road.
But she said her road leads up to this. Her road is the road that you access this property from.
Yeah. So,
Right.
yeah, if I could, so Indian Mound wraps, it like kind of comes through and then has another
It's
exit.
a
There's,
half moon, right? It's a.
yeah, exactly. And then there's also one that comes in through the center called Cherokee Road.
Yeah.
We do absolutely everything we can to keep people from coming down in the bottom. There actually used to be a one-way sign down at the bottom. That was great. I don't know what happened to that. I've ordered new signs, and I want to communicate with Molly to see if we can put those signs back up. Happy to pay for those, happy to install them myself. Because that section of road is really not great. Largely because you have to drive up, and it's very, very steep.
Sure.
We've petitioned Google Maps to change the directions. It's really not a through street. So, as I say, there was a one-way sign that was great. Why it's not there anymore, I'm not exactly sure. She's right that I've never contributed to road maintenance down at the far end of Indian Mound, largely because we never use it and we don't direct anybody to use it ever. Would never do that. And also, I do think that if people were using it, we would know, honestly, because they would end up in the ditch. But I would honestly be happy to work with her to do road maintenance. I'd be happy to do road maintenance all over the place. It's,
Well, there's no requirement that you have to. 'Cause
There's no
obviously you're not
requirement, but-
associated with them, yeah.
Yeah, but I mean, just related to that, though, I mean, that's sort of the difficulty is that for people who are living in the neighborhood, they don't maintain the road. There's no real reason for them to maintain the road. Whereas there's a very strong reason for us to maintain the road, which is why we do it. Not because we have to, but because we have guests coming on the property and they pay good money to come onto the property, and so that's why we maintain the road. So it is really the Airbnbs that maintain the road. But
Other questions, comments? Okay. Anyone here to speak on public comment? I don't think so. Okay. Anything, yes, please.
This is, for Kurt, actually, okay. So, he mentioned he did these things that came up concern last hearing, and nothing in writing, okay? So where's this, if we just vote, make the assumption that what he told us is the truth, and no disrespect.
I could show receipts for the gravel.
Yeah, I'm just looking at it from a legal standpoint. And these things didn't happen, and the board approves it, where does this leave us legally?
Well, I think a lot of the stuff that you're talking about doesn't necessarily have anything to do with the actual request that is before us. I obviously think that, most people try to show that they're actively addressing their neighbors' concerns, but I believe the question before you is really whether he can have a vacation rental complex. So I think from a legal standpoint, once you grant the special use permit, he will be allowed to use the property as you've specified in the permit. But road maintenance agreements and things like that, I don't think that that is a condition for the permit. So I don't think that would put you in a bad spot, or the county or anybody in a bad legal position.
Hearing no other questions at the moment. Any other closing statements, and we'll get to deliberation.
I mean, only related to what Kurt was saying, that I'm not aware of any conditions that we don't meet for the special use permit, which I do think is, I think pretty important. And some of these things I'm bringing up largely because they're concerns of the neighborhood, but we've tried to be very diligent on the permit application to make sure that we qualified and met every requirement, which I believe that we do.
Okay. Thank you very much. Close the public hearing and move to board discussion, deliberation, and a motion.
I have a question. So they already have two Airbnbs on this property or using this road. So the effect of granting this would be to allow the home that they are currently occupying to also be used as an Airbnb. So essentially converting what is now a single-family residence to something that could be rented. Is that correct? That would be the net effect? And I mean, just following me
Yes.
through the thought here, again, not perhaps relevant to the decision-making, but being familiar with that business, I'm assuming an Airbnb would generate a lot less traffic on an annual basis than a family living there. I mean, I think most Airbnbs have several months of pretty much silence. And if we are trying to consider the feelings of the neighbors, I think the net effect would be a reduction of overall traffic on the road, for what it's worth.
That's a good point. We did also discuss last month, or the hearing before that, the parking minimums, and that they had satisfied that requirement. So.
I'm glad to hear that they have a solution to address the other witnesses' concern about the turnaround. But at the end of the day, I agree that there really shouldn't be a reason why they've satisfied the requirements for the Airbnb, and we've heard the concerns, and they sound like they've been addressed. There's no guarantee that they'll continue to be addressed, but we can't assume that they won't be. Yeah.
Okay, we'll open it up for a motion.
Mr. Chair, based upon the evidence presented to this board, including the following exhibits: the petitioner's application, the submitted development plan, the GIS maps, the staff report, testimony presenting at the hearing, I move that this board adopt the following findings of fact. That this matter was properly advertised and is with the board's jurisdiction and is ripe for its consideration. That this application together does with the conditions proposed by staff and/or this board and agreed to by the applicant, if any, does meet the requirements for granting the special use permit? Right?
There
Or
may not
variance,
be
it's a variance. Maybe you're reading the wrong
You'll have
thing.
to reuse one of the ones from the Clayton Crossing or the River's Edge, because I don't think we have a motion worksheet
Oh,
for this
Clayton,
specific
okay, here
case.
it is,
Yeah.
sorry. Does meet the requirements
For a vacation,
special-
for a vacation.
vacation
special use
rental,
permit For a vacation rental.
special use rental,
Okay, just a special use permit.
special use permit contained in Buncombe County Code of Ordinances, section 786213.
There's been a motion on findings of fact. Is there a second? Hearing a motion, a second. All those in favor, please say aye.
Aye.
Aye. Any opposed, nay? That passes.
All right, based on the foregoing findings of fact and for reasons set forth therein, I move that the requested special use permit be approved and that the order approving the permit be adopted and executed as presented and modified in this meeting.
There's been an approval motion. Is there a second?
Second.
All those in favor, please say aye. Aye. Any opposed, nay? That motion passes. Thank you very much. We'll move to discussion of an order.
Basically the same thing, the only, this is basically a standard or special use permit, except there's slightly different standards from a PUD as opposed to a vacation rental complex. I just want to point those out to you that we'll be using the standards set forth in 678B9 for a vacation rental complex, that the minimum distance between the buildings shall be 20 feet or other as specified by the board. The preliminary plans do include parking provisions that provide at least one space for the two proposed guests will be visually screened with fencing. The freestanding signage will be shown on the submitted plan, will not exceed 10 feet in surface area, and one bedroom for every 4 guest rooms will be provided. The proposed use will not adversely affect the health, safety of persons residing in the neighborhood. The proposed use will not be detrimental to the public welfare. The proposed use will not have an adverse effect on the surrounding properties due to noise, vibration, odor, or glare effects. And this is the one that you all were talking about. Satisfactory ingress and egress for the proposed use of the property and proposed structures has been provided. Provisions for off-street parking have been arranged for. Provisions for proper utilities have been arranged for. If necessary, provisions for buffering have been arranged for. I'm also going to say that signs are in harmony with the property in the district, and if applicable, that playgrounds, open spaces, and pedestrian ways have been arranged for. The building structures regarding to size and use are acceptable, and the hours of operation are acceptable. The following conditions: the project must be constructed as depicted in the site plan. We have no other special, we have our usual conditions. I'm not going to read through all those. And then that the owner needs to agree to these conditions before they're able to convert to be a vacation rental complex. And that's it. And that based on that this meets the standards of the zoning ordinance, and that the applicant is hereby granted a special use permit.
Thank you so much. Any questions, comments, corrections, or a motion on that order?
Motion to adopt the order?
There's a motion. Is
Second.
there a second? I hear a second. All those in favor, please say aye.
Aye.
Aye. Any opposed, nay? That passes. Thank you so much. Appreciate it.
Congratulations.
I'll email
Congratulations.
when we get everything.
Best of luck. Any other business before the board? Any? Yes.
I just wanted to ask the board, would it be helpful if I put together something regarding variances and hardships and kind of a summary for you all, kind of what the status of law is? I want to try to be helpful, and I just don't know if that's something that you would like to have as a. No, I hear what, yeah,
We are working off the ordinance right now in that paragraph of 4 items, and that's hard to encapsulate everything.
oh, no, well,
within
there's
those
been
4.
case law, and there's been other things that aren't necessarily reflected in our ordinance, and I just want to make sure, obviously, we want to try to help people do what they can do, but, also, and I appreciate that you all, will follow the law, even though it might not,
Feel good.
be the easiest thing to do. So I just, but I also want to make sure that we try to put, our residents in a position to succeed with their projects. So I'm just, just wanted to make sure that I tried to help streamline that for y'all.
I think it's worth noting, when zoning first came in, we actually had a lot of these, hiccups, problems that were, nobody created, they just happened. And I think the board was fairly amicable about trying to correct those situations that were really nobody's fault. This one is just very late to the game.
Sure.
Right. Mhm.
Joel, is your microphone on?
Saying, basically saying, he built this garage, violated setbacks, and I believe his case was he's subject to these hardships. Even though you can look at it, he created his hardship. And I realize you try to work with it. But, I think it makes the board a little bit easier if they get some clarity in these things.
Yeah, and if there's anything else that you all need that I can provide to help make, because like we don't have like continuing education, we don't have like workshops and stuff like that. So if there's anything that I can do to help make your job easier, please let me know.
Well, has everybody gone through that Board of Adjustment training?
We were waiting for next year when the school government offered it. They're offering it odd year in every other year now.
Okay.
So we can't do it until.
I'll also add that we, I believe it was actually just last week, that the planning director, Nate Pennington, he reviewed some materials that Savannah Glantz and I had worked on, that were essentially like orientation materials for new board members. But of course, we'd be happy to share those with all of you as existing members if you would find those resources useful. They contain just general overviews of the board's responsibilities. There's also some references to case law and some explanation of some of the legal concepts included in all of that as well.
I think it would be useful.
Yeah,
why not?
and another thing is, I know for all of the members who were appointed to the board during the time that I have been clerk, you all would have received a copy of the UNC School of Government quasi-judicial handbook.
Yeah.
If you don't have a copy of that, we can absolutely get one for you.
Yeah, I know they ran that workshop in Biltmore Park, which I attended. I don't know if anyone attended, put on by someone UNC government. And I didn't come away from that very impressed. The guy got bogged down in war stories regarding zoning and everything else, rather than maybe looking at a little bit bigger picture. of
I
the
actually
board
like the war
roles and
stories.
Things like that.
Because then it gave me actual context on how do people think about, think about the issues and all that. That's how I learn, is by example, kinesthetic learner.
So yeah, we'll look at that early next year whenever they start offering those.
I didn't mean to, I know everybody, it's been a long day, but I really want to make sure that you all know that, staff and we are all here to help support you and make sure that, I just want to make sure that things are smooth, try to make things as smooth as possible. That's probably a unrealistic goal, but.
Yeah, one question I have for
Case
Kurt.
law evolves. It always does, so, but
Is what you're talking about doing on top of what's in that manual? Do you, the variances chapter?
Yes, because I'm not sure that, that you get the full story. Sometimes those are probably like 50,000 foot level. And I just want to make sure that you have everything current, because, that, like, trying to figure out what a hardship is not the easiest thing to do. So I just want to try to provide you with as much information so that more or less you can make the best informed decision that you can.
Yep. Thank you, Kurt, so much.
Thanks for your time.
Thank you. All right, any other business? If not, is there a motion?
I make a motion to adjourn.
I hear a motion and a second. All those in favor, please say aye. Aye. Any opposed? Nay? Thank you. Thank you all. That was wonderful.
No,